Officer, you may.
Good morning. The 36th District Court is in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. At this time, there will be no talking, sleeping, chewing gum, reading of any materials, or driving. Thank you.
Thank you, Madam Officer. All right, this is case number 22-242955. This is James Willis versus City of Detroit, or City of Detroit Clerk et al. The matter is before the court, set on for a pretrial conference. Do I have Mr. James Willis on the Zoom, please? All right, unmute yourself, Mr. Willis. Good morning to you, sir. Let me have the appearance for the City of Detroit.
Good morning, Your Honor. Christopher Michaels, P83156, on behalf of the city.
Thank you, Mr. Michaels. Mr. Willis, good morning to you, sir. You're still on mute, and I'm trying to get you off mute there, Mr. Willis. So if you hit *6, that should get you off, sir. There you go. Good morning.
Good morning.
All right, thank you, sir. All right, I set this up for a pretrial conference on today's date. I also issued an order previously in December allowing for the filing of a more definite statement, and looks like you have received here. I received a plaintiff statement of facts dated the 23rd of January. All right, for the city, have you received a copy of that document, counsel?
I did, Your Honor. I actually received it yesterday, but the mailing indicates it was mailed on the 23rd as well. So.
All right, very well. The order required that the more definite statement be filed by the 4th of January. Why did you file the statement prior to the 23rd, Mr. Willis?
Well, I was told to file this statement by the 4th.
Yes. You filed it on the 23rd of January.
No, I filed a more definite statement on the 4th.
That's 22-242955. I don't see that. All right, Counsel, did you receive the more definite statement?
I did receive it yesterday, Your Honor, and it states in the actual statement itself that it was filed with the court and mailed on January 23rd. So I don't know if he did file anything by the 4th. I did not receive anything until yesterday.
That's what I'm looking at. I think what the gentleman is referring to, he did file something on the, looks like the 29th of December. It says motion to reconsider the order for one definite statement. And then attached to that is, it has a document called plaintiff's more definite statement. And the more definite statement, or the item offered as a more definite statement, is plaintiff states the following in the above reference matter: the plaintiff agent and Detroit's and compliance inspector during the construction of emergency repairs on plaintiff's home. Defendant failed to meet even a minimum standard set forth in the City of Detroit Housing and Revitalization Department's contracted performance standards, not complete all work and specifications described in the contract. That's the more definite statement that defendant authors. He also authored the motion for reconsideration of a more definite statement. And in filing his motion, I don't know if you received these items, counsel. It says, defendant's motion for definite statement does not meet the requirements of MCR 4306C1 to file a motion for a definite statement. All right, so that's the gist of it here. Have you received that motion for reconsideration of the more definite statement, Council?
I did not receive it. I see it's on, there is on the register of actions that a motion was paid on the 29th. I did not receive any motion from Mr. Willis. But having just received the statement of facts, it appears to be some sort of dispute with his contractor. So I'm not even sure what the allegations against the city are. It appears, though I haven't had much time to review it, Your Honor, because I did receive it only yesterday. But
all right. So, Mr. Willis, it sounds like the agent, the attorney for the city of Detroit is indicating that they did not receive a copy of the earlier document, that they did receive a copy of the plaintiff's statement. So let me ask you, Counsel, regarding the statement of facts that you did receive, you indicated as it's timestamped on the 23rd. Does that change anything regarding your thoughts about the motion for reconsideration regarding this matter?
Your Honor, I have a plaintiff's more definite statement. I have a plaintiff's more definite statement that's dated, that's stamped by the court on December 29th.
Okay, I cut you off because I already said that. Hopefully you were able to hear me, that I received that. What I pointed out to you is that the city of Detroit indicated that they have not, they did not receive a copy of that. They did receive a copy of the document that you submitted on the 23rd. I already covered that. What I'm asking the city now is whether or not their position changes regarding a more definite statement based upon the statement of facts that was submitted on the 23rd of January. And I'll come back to you, Mr. Willis. Mr. Michaels.
Your Honor, well, it does allege there are facts sufficient that the city could file a motion or answer. It does appear that he doesn't have a claim upon which relief can be granted, but I think he did sufficiently provide at least enough factual allegations to let the city respond to the pleading. I guess I would just note that the court did order it to be filed by January 4th. It wasn't filed until the 23rd, and the order itself indicates that failure to timely file the more definite statement will result in dismissal of this case. And the city is to save the time of the taxpayers' resources and this court's time. I think dismissal at this point would be the best course of action. But as far as answering the court's question, I think there are statements of facts in this that allow a responsive motion to be filed.
Thank you, Counsel. Coming back to Mr. Willis, it seems to me that while there may have been a failure with regard to mailing the plaintiff's motion for reconsideration, the plaintiff did timely file the motion for reconsideration, and he attached to that a purported more definite statement. But even if there was not a purported more definite statement, the fact that he filed a timely motion for reconsideration would be enough to toll the time for the filing of the reconsideration. For the filing of the motion for the more definite statement. Under all of the circumstances here, let me hear from Mr. Willis. But I think I think what I'm going to do in this regard, number one, I'll deny the motion for reconsideration in this matter, finding simply that the motion for reconsideration is not well founded in this matter. I will conclude that based upon the plaintiff's offer of a more definite statement, as well as the plaintiff's statement of facts, that information is sufficient information to give plaintiff a basis to proceed by way of answering the complaint. And with that in mind, I'll require that the plaintiff file an answer or a proper motion within the next 21 days regarding this matter. And those are, that's the direction I believe this case should go. Mr. Willis, before I go further, sir, let me know if you've heard what I said and then tell me anything you wish to add at this time, sir. Let's see if we can get you off of mute there. There you go. You're still on mute, so go ahead. See if you can unmute yourself, sir.
Okay. Now, what was your question, Judge?
Oh, no, I was saying you've heard the decision that I made on the part of this case. Anything you wanted to say or anything you wanted to bring to my attention at this time?
Well, I'd like to bring to your attention that everything that that I was supposed to have filed was filed timely, and I have documented proof that it was, and there is nothing that has been left undone that I was supposed to have done. And so I don't understand why none of this is a matter of record, because it's stamped by the court. And it was everything that I filed, I mailed it to the attorney for the city. So I'm not sure exactly what it is that is lacking.
All right, were you able to hear anything that I said? Any of my
Well,
conclusions?
I can hear you. I could hear you, but not entirely.
Okay, all right.
My hearing isn't that great, Judge. I'm sorry.
All right, we won't hold that against you. Okay, you're right as it relates to the timely filing of documents. The sequence of things were a little bit different because of the filing of that motion, but subsequently you filed another document. The motion was timely filed, and that's the critical issue here. And so my decision is that I'm denying the motion for reconsideration. I'm accepting your more definite statement, also your statement of facts. That gives the city of Detroit what it needs to either answer or go forward in this case if they choose to. They have 21 days to answer the information that you put out there. And if they don't answer in within 21 days, then a default will be entered regarding this case. If they answer, then the case will proceed from that point. They can file an answer or they can file a motion. And whatever they file, they have to serve a copy on you. And I'm going to set a hearing so that we can go forward from that time. So the motion regarding any motion regarding this matter or answer a motion that might be filed in this matter would have to be filed on or before the 16th of February. On or before the 16th of February, and the court will set a hearing on this matter. That hearing be set for the 27th of February. 27th of February. I'll set that as a pretrial hearing date and or a motion hearing date. Well, let's do it this way, because if they file a motion, sir, you're gonna have to respond to a motion if they file a motion. If there's an answer, you don't necessarily have to respond to an answer, but you'll need time to respond to the motion if they file a motion. So they have to file their motion if they file one by the 16th of February. I'm going to put it out a little further to give you time to file a response. Your response to the motion that they might file would have to be filed by the, one second, sir. By the 6th of March, March 6th, and the court will conduct a hearing on that matter on the 14th, March 14th. So next action date is going to be March 14th. The dates for filing and responses have been set for as the 16th of February and the 6th of March respectively. And then the hearing is set for the 14th of March. I will send you out an order with those dates in it. The most critical date, of course, you know, all of them are critical, but the 14th of March is a critical date to note because that's the date you come back to see me. The time on that is going to be 9:45 a.m. 3/14, 9:45 a.m. All right. gentlemen, and so I'll send you out an order with that information, and I expect the answer by the 16th of February, no later. And the, any response, any written response to any motion that might be filed by the 6th of March of 2023. The hearing is on the 14th at 9:45 a.m. All right, good day to you, gentlemen. You'll get an order from me in the next couple of days.
Thank you, Your Honor.
Thank you. Good day to you. All right, the board now calls SC 18241-991. This is Jones Owani versus Reina Al-Hadi et al. Now, the matter is before the court. Sent on for review. The parties have been moving towards obtaining possession of certain containers that are in Nigeria for purposes of trying to move this case forward. Your appearance for plaintiff regarding this matter.
David Palmieri, P26796 for the plaintiff, Your Honor.
And one of Your Honor, may it please the court, Michael Elkins appearing on behalf of defendants, P29725.
Thank you, Mr. Elkins, and good morning to you, and good morning also to Mr. Olney. Good morning to you, sir. Right. Somebody update me. Where are we? I know it's only been a week ago.
I'm pleased to advise the court that we actually seem to be making some progress. Received information on Tuesday afternoon from plaintiff's counsel as for contacting Mr. Onweno's agent in Nigeria. I forwarded that Tuesday night or Wednesday morning, as it was, to my client, who was contacting his agent, who sent the information to his agent, and that was sometime yesterday. So I'm waiting to, they should be reaching out to make a contact to set a time to open the container.
Right. Mr. Palmieri, you seem like you have something else to add to this.
I actually don't, Your Honor, except to note that both of the Nigerian agents of the parties here have each other's contact information. Nigeria is 6 hours ahead of us. It's 4 o'clock, just after there. And I believe that as of this moment, or as the start of this session of court, that neither side had actually reached the other side, but they're trying. So that's progress. Whatever the court's pleasure is at this point, I think the parties wish to continue, but we understand we are trying the court's patience severely.
Mr. Olinu, thank you for your engagement on last week and some information regarding this matter. Anything you wanted to add at this time, sir? Anything you wanted to bring to my attention, sir?
Myself, Your Honor, I thank you very much for your patience. But you know, you've been in this business for many years. It's costing me money and wearing me out. So whatever the court can do, I'll be very happy.
Thank you, sir.
Yes, sir.
Well, I guess the best thing that I can do is keep this close to the chest, if you will, and bring it back just to make sure that things are going along. So I think that if I bring it back, rather than set it on some long adjournment, if I bring it back in 2 weeks, that will make sure that everything is moving along, and that the court will take whatever action it can to try to get to the conclusion here, because I know this has been an ordeal. So that would put us, that would actually, I'd have to do it the 8th of February. Sure that we're not getting too far out there.
If I could ask the court's indulgence, I will be out of town that week. If we can make it the 16th, it would be an accommodation to my schedule.
Judge, I don't mind accommodating Mr. Elkins' schedule. He's a good guy. I'm going to be in trial on the 16th in Wayne Circuit Court. So May I ask Mr. Elkins when he's leaving, and maybe we could do it a little sooner rather than later.
I'm leaving Saturday, 2 days.
I'm thinking
Oh.
Thursday. Can we try that Monday morning at maybe 10 o'clock?
I'm sorry, which Monday? Your Honor?
February 13th, 10 o'clock AM.
I will still be out of town, Your Honor. I'm coming back on the 14th.
Oh, I got you. I got you.
I'm starting trial on the 14th.
Happy Valentine's Day.
Yeah, indeed.
All right. So I can take I think did I already put out there that the 8th? The 8th didn't work for some reason. Somebody was out of town then. The 8th of February.
I'm out of town, Your Honor, yes.
May I ask Mr. Elkins, is there any chance he could take a laptop or some other device with him? It's a Zoom hearing. You can do it from anywhere in the world.
Well, I'm trying to avoid taking a suit, but
I was gonna say that the answer to that question depends on who he's taking with him.
Fair enough, Your Honor.
So that's not gonna work. I definitely prefer sooner rather than later. But if we have to, I can stretch it out to the 20th. Again, we're getting out there. 20th of February.
20th works for me, Your Honor.
I'm just taking a quick gander.
If you start a trial on the 14th, and you know how that goes.
The February 20th appears to be President's Day, Your Honor. I don't know if the court will be open.
We're closed that day, 21st.
And what time would that be, Your Honor?
10 o'clock.
I would have to move a doctor's appointment, but I don't want to tie up the court's docket any more than I have.
All right. Well, we want you to make those doctor's appointments. What time is your doctor's appointment?
10 o'clock.
Let's do it at 11 o'clock. You think that works better? You can still hold the doctor's appointment?
We push it 11, perhaps 11:30. I just don't know how long I'm going to be tied up at the doctor's. I get there on time and I wait.
My sister's a doctor. Sounds like things have not changed.
Perhaps the afternoon.
Okay, well, I want to make sure you're able to be here. So let's move it on to the 22nd.
22nd is good, Your Honor.
Also good for myself. Thank you, Your Honor.
Thank you.
2/22/23 at 10 o'clock AM. And
Thank you, Your Honor.
Let's get these agents moving in any way that you can.
Absolutely.
Once we got some control over it, then we get things back here locally, and the court can exercise more authority on some things. But as long as it's in Nigeria, it's only so much that we can do.
Yes.
So
Thank you.
2/22 at 10 o'clock.
Thank you, Your Honor.
All right,
Thank you.
gentlemen.
Thank you, counsel.
All right, we're on record in case number 21-168087. This is Huron Case Management versus City of Detroit Department of Transportation. It looks like, I think this is just City of Detroit, but it looks like the law department might have been sued or something. Anyway, your appearance for Huron Case Management, please.
Your Honor, Mike Xavier on behalf of Huron Case Management.
And your P number, if you will, Mr. Zanon, just for the record, sir.
P76438, Judge.
All right, thank you, counsel. Good morning to you. Counsel, proceed.
Good morning, Your Honor. Philip Hiltner, P77913.
Good morning, Mr. Hilner, to you at the wonderful snowy day yesterday.
Yeah, thank you.
All right, what do we have going on here? I see that, I think I missed something here, and that looks like a motion for summary disposition that was filed in December.
Well, Your Honor, we We asked to have the motion for summary disposition deadline moved, and Your Honor moved the hearing then to today's date. But we have not been able to write that motion just due to circumstances out of our control. We need the depositions of some of Jamela Shannon, who is the underlying claimant in this case. And she has her own circuit court case, and we're trying to get depositions of her mother and stepfather. And we've subpoenaed them twice. They did not appear, so we got an order to compel. And since we've had the order to compel, we've subpoenaed them again. So we anticipate taking their depositions finally at the end of February. And then at that point, we'll know whether or not we can file a motion for summary disposition.
All right, I got it. I think well, I'm looking now, I issued an order in December that extended.
Excuse me, is there any way I can interrupt to get to the right courtroom?
Not now, you can't interrupt the hearing now. Just stay right there. I'll be with you in a moment.
Okay.
Right, okay, so Mr. Xavier, anything in this regard, sir?
No, Judge, we do have a deposition of the case manager that for my client that did provide services to Ms. Shannon coming up in the next couple of weeks, but I don't dispute that there's a bunch of other cases with her underlying claim that we do have discovery plan that will affect our case in the meantime. So I don't know if just a limited period of additional discovery and hopefully everybody appears when they're supposed to, and cross our fingers and we can just have a comeback date to make sure everything is done and discovery is done. Because again, I don't dispute that he may have an MSD claim pending the results of what comes out in the deposition. So I certainly think they do need it for both our case and all the other underlying matters.
All right, it looks like I issued a pretrial schedule, just going back to the 5, and that pretrial scheduling order has you set up to come see me on the 16th of March. Oh no, that was last year. Okay. All right, now I'm up to speed. Okay, here's where it looks like the parties have been progressing as far as discovery has been concerned. A few hitches along the way. And both parties kind of concede at this point that it is meaningful that discovery opportunities continue, and that the court leave open an opportunity for filing of motions dispositive or otherwise. That seems to be reasonable under the circumstances herein. For that reason, I'm going to set this matter out. I will allow discovery to be continued until the next action date. And I'm going to set a date that is a bit of a control date in this matter. And so I'm going to set that date for the 30th of March. And that will give an opportunity to file motions and have them heard on that date. Only thing that would be required is if a motion is filed, it has to allow at least 10 days before the hearing for the other party to respond. So if Mr. Hillman was going to file a dispositive motion or otherwise, we would have to file it and make sure that Mr. Xavier received 10 days notice prior to the hearing, and I would hear it on the 30th. Now, I know that your depositions, I think you told me depositions are running near the end of February. So do I need to move that date into April?
I think end of March could probably do it. I think that'd be okay if we have the depositions and all the other discovery taken care of by end of February. That gives
Judge,
us
I think that date works fine as long as everyone cooperates and appears. Then I think we have plenty of time to solve, and I may even stipulate to something if depending on what the testimony is.
So I'm going to go ahead and set it for the 30th. Discovery remains open through that time. And again, my standard order would apply, allowing for the filing of motions to be heard on that day, so long as there is the opposing party has at least 10 days notice of the motion, and I'll hear it on that day. You guys are moving along without any significant hitches, except the fact that other people may not do what they're supposed to do. So if for some reason you need to extend that, then the court would be open to that. I mean, it doesn't seem like this is a sandbag kind of case or anything like that. It's just getting all the ducks lined up to see where the case goes. So if there's a problem, let me know and we'll adjust the date. But I'm going to set it for the 30th of March now and set that for 9:45 a.m. 3:30, 23 at 9:45 a.m. And I'll send out a scheduling order that has this information in it. But you already have the date and I think both sides know which direction this case is going. So
That was 9:45 on March 30th, Judge.
That's correct, Mr. Xavier.
Thank you.
All right, good day to you, gentlemen.
Thank you, Judge.
Thank you, Your Honor. Take care.
All right, Mr. Ward.
Yes.
What is, go ahead, talk to me.
I am trying to determine whether or not if I'm in the right courtroom. I'm supposed to have a hearing with Lisa Jones Coleman at 10:25. Case number 2.
I don't look like an Alicia.
I understand. I'm a little confused because the website says her
Yeah.
courtroom is 5:34 and I see 5:34 on my phone.
All right,
I can give you,
that's
go
where
ahead.
you're supposed to be. But let me give you, so you're supposed to be in under that 534. It may have redirected you here, but that's where you're supposed to be. And let me give you the courtroom phone number there as well, so that you can call over to the courtroom. You got something to write that down, sir?
Yes, I have a pen and paper right now.
All right, that number is 965 22 9 what? 92 2292 965 92.
965-2292. Let me confirm that I have the right case number. I have written down 2238-5071.
No, please, that's a landlord tenant case. His name is who?
His name is Pierce. You Mr. Ward, Pierce Ward.
Yes, I am.
Yeah, you're in the way wrong place. You're supposed to be in landlord tenant stuff, right?
Yeah, I have
Yeah.
information. He did have a case for January the 26th. Your case is dismissed.
Case is dismissed.
Oh, really?
Yes, they entered a dismissal on December the 29th.
Oh. Well, what do I do at this point? I'm a little confused. I know I owe money. I was calling and making arrangements to get it resolved.
Until they bring some other case against you, this case is the one that you gave us, that case is dismissed. So if they want to come after you for something else, then they have to file a new case or restart it, but it's dismissed.
And is there any way that you can check?
Hold on one second.
The phone number to the court.
You have it? Okay, and I'm gonna give you the phone number to the courtroom that you, if you want to reach out to them, ask more questions. That phone number is 965.
Yep.
2404.
2404. Okay, I have 965-2404.
That's
And I
correct.
also have 965-2292. Is that correct?
Ignore the previous one. You just want to deal with 2404.
Got it. I'm going to call them and they can give me information regarding my case. Is that correct?
They can, they'll confirm that the case is dismissed, sir. All right, good day to you.
All right, thank you.
Still have this Langford in there for the, they should have a court date today.
All right, this is case number 22-197491. This is Crystal Langford versus Paisley McGee. The matter is before the court, set on for a trial evidentiary hearing. The day is daytime set for such matter. All right, do I have Crystal Langford on this Zoom? Say something if you're here.
Christine Langford.
All right, thank you, Ms. Langford, and good morning to you, ma'am.
Good morning.
All right, do I have, I believe it's Paisley McGee on the Zoom. If you're here, say something, ma'am.
Yes, I'm here.
All right, thank you, Ms. McGee, and good morning to you as well. Let me have the two of you raise your right hand to be sworn regarding the matter before the court at this time. You do solemnly swear or affirm that the testimony that you're about to give in the matter before the court is the truth and nothing but the truth, so help you God.
Yes.
Swearing.
All right, very well. Thank you to both of you. This is a case in which Ms. Langford has to prove by preponderance of evidence regarding the claims asserted herein. Therefore, under law, she has the right to go forward first. She therefore has the right to present her evidence first, also to give an opening statement if she desires to do so. And after the presentation of Ms. Langford's case, Ms. McGee, you have the opportunity to cross-examine her or ask questions regarding any issues that she may have brought up before the court or any issues that may be relevant to the outcome of this case. After cross-examination, after Ms. Langford has presented her side of the case, then Ms. Paisley, you will, Ms. McGee, you will have the opportunity to present your side of this matter. You will have an opportunity to make an open statement. You can do it at the beginning, or you could wait until the beginning of your case to make an open statement. After the open statement, you have opportunity to present any proofs that you might wish to present to the court. And after you've presented any statements that you wish to present, Ms. Langford will have opportunity to ask questions of you if she chooses to do so. That's also called cross-examination. After both sides have presented their evidence, both sides will be given an opportunity to make what's called a closing statement, a summary of what you believe the case has shown and your petition as to what you're asking the court to do. And so that's the procedure that we will follow in this matter. I do not allow interruptions. When the court is talking, then no one else is talking. When another party is talking, then the other party may not interrupt until the proper time to make inquiry. Remember that you will have an opportunity to ask questions if you choose to do so. The questions must be focused and must be appropriate under the court rules. Otherwise, the court will not allow the questions. All right. That is the procedure that we will follow in this matter. The question now is, Ms. Langford wish to make an opening statement before proceeding with the presentation of proof in this matter.
I have documentation of multiple instances
My
where,
question to you is, would you like to make an opening statement at this time?
yes,
All right, you may proceed with your opening statement.
I have multiple pieces of documentation, video footage, and 911 audio of Miss McGee making false statements to the police and the 911 operators. She initially advised that I was out of town for a couple of days. My dogs did not have food or water. She, on Ring camera footage, contacted 911 and called the police, came back, fed them a different brand of dog food, strawberries, and water, and also put water on the floor. After I had the conversation with her on the Ring camera footage and requesting for her to leave my home, a couple of days later, there was a wellness check done by the Detroit police. Initially, I thought that Miss McGee had genuine intent. Later on, after reviewing the video footage, it was malicious intent. That's all I have to say.
All right, thank you very much, ma'am. Now, Ms. McGee, you can make your opening statement now if you wish to do so, or you can wait until it's time for you to present your case and make your opening statement. Then you have that option of choice. Would you like to make an opening statement at this time?
No, I'll wait.
All right, very well. Ms. McGee, having reserved her opening statement, Ms. Langford, you may proceed now with the presentation of your evidence in this case. You can offer that by way of testimony, and you can also make reference to to documents. As we do that, let me begin with a couple of things here. Miss McGee, this case, based upon the opening statement made by Ms. Langford, involves claims that you called the police department on more than one occasion to make reference to a wellness check and to make reference to dogs being on the premises and not being fed. Did you make phone calls to the police department regarding the dogs, regarding wellness checks on Miss Langford?
Yes, I did.
And do you recall how many times you made any calls or statements to law enforcement regarding this case?
Yes, I called June 18th and 19th, so Saturday and Sunday. And then I believe I made another phone call on June the 26th of last year, 2022.
All right, thank you. All right, and you may begin your case now, ma'am, there's a stipulation on the record that phone calls were made to law enforcement on June 18th, 19th, and 26th. That is an undisputed fact in this matter, and that those calls, as have been indicated by Ms. McGee, were in regard to dogs on the premises not being fed and the wellness check. You may proceed with that in mind. That's not contested. Go ahead, ma'am.
It's not allowing me to do the screen sharing. Is there any way that feature can be enabled?
Yeah. I believe it's enabled now, ma'am.
Okay, thank you. Sorry, I was coughing.
And you can't offer anything on the screen until you tell me what you're offering, ma'am. That's all. Talk to me.
Okay. I'm in the process of pulling up the initial ring footage showing where I left my home on June 18th around 8:30, 9 o'clock a.m. I returned home on June 19th around 12 o'clock, 12:15 a.m. I also have video footage showing me interacting with the dogs back and forth while I was packing up. I also have the initial ring footage that I found when Miss McGee and her girlfriend initially arrived to my home. The intermittent footage of them coming back, as well as the 911 calls, and also the documentation that I provided Miss McGee showing that I had been home and been gone no longer than 24 hours.
All right. Miss McGee, do you dispute that this video footage showing when Miss Langford left her home, and that there was some discussion with you where she indicated that she had been gone for less than 24 hours? Did she tell you that?
I dispute 100% the timing because we had a phone call day of. So I just dispute the timing.
Okay, let me ask you this. Excuse me. And let me ask you this as well. What happens in a trial is that the court does not allow minutia regarding minute details over and over again, where there is stuff that is either not in significant dispute or issues that are altogether irrelevant. And what it seems to me, as it relates to the facts here, is that there may be a dispute regarding how long Ms. Langford was at home, whether she left her home, whether she returned to her home. Those things are not really relevant here. What's relevant here is that I believe there is a stipulated fact that, and this is a question I want to ask Ms. McGee. You came to the home. You came to the home at some point, somewhere. I believe the 18th and 19th or somewhere around that time in June last year.
The 19th.
19th. Been on the Zoom camera indicating that you were there on the property. And is that the time at which you put you brought some dog food or strawberries or something? Tell me what you brought.
That's correct. I had dog food and strawberries that I put in a bowl, and there was also a second bowl of water.
You don't know how long. You don't know how long Miss Langford had been away from the home or at the home at the time that you did that. Is that correct?
That's correct.
All right, so those facts are covered, that there was, various items that were brought to the home that, the defendant doesn't know how long you were not there, and it's not particularly relevant. None of those things are particularly relevant. Ms. McGee came to your home. She, brought some dog food, some strawberries and some water, to feed your dogs. That was not something that you permitted. That's something that you did. And, those facts are that I don't need to see a whole lot of video there. You can tell me, when you left the house, when you were at your home, and I think your testimony is that you didn't invite anybody to feed your dogs, correct?
Correct, as well as Ms. McGee has not had enough interaction to be aware of their dietary restrictions.
You don't, Ms. McGee, you don't feed these dogs, or you didn't feed or deal with these dogs prior to coming to the home, correct?
No, Your Honor, I just did research based off of what she posted in May, and I also submitted that to the court. I just did necessary research to know exactly what they eat since I was doing the wellness. Okay.
To that testimony, ma'am. All right.
Okay.
Continue, Ms. Langer.
I'm sorry, can you repeat that, Your Honor?
I said you can continue at this time. The indication is consistent with your testimony at this point, that she did not feed these dogs on a regular basis. She was not involved with their diet. She indicates that she may have some testimony regarding some research she did in May, but you may continue.
Okay. Despite the research that she's done, if her and I have not had any contact since December, it's not acceptable for her to come to my property unannounced and then feed my animals, which then they later became sick as a result of the food that she gave them. The food is in the process of being tested by the University of Michigan veterinary labs. I dropped the sample off Friday. They did advise that the trace sample and microelement samples for both my dog food and the food that she provided should be available within that 7 to 10 day time frame. And I do have the receipt if the court would like to see that as well.
May continue, ma'am. I don't need to see the receipt for that.
Okay.
What happened? You may continue in the fashion that you wish, but I need you to answer the question relative to what happened as a result of feeding the dogs, that kind of thing.
Okay. After she fed the dogs, the youngest German Shepherd got sick around 9 o'clock that morning on the 20th. The older German Shepherd got sick around 7 a.m. on the 21st. I do have documentation of the vomit and vial that they spit up. I also do have recordings for the vet that we went to. And again, I do have documentation of her filing these false police reports. That's where I'm kind of concerned in regards to where the timing doesn't matter. If I've been gone then less than 24 hours, I'm not understanding how these dogs are being abused and neglected.
Well, whether the reason that the timing does not matter is that the defendant responds to supplying the dog with food. That's not something that was your desire anyway. And whether or not they were being neglected or not, your position is that they were not being neglected. And if you had been away from the home longer than 48 hours, I believe your testimony would be that you made provisions for the dogs notwithstanding. I believe your testimony is that you did nothing under any circumstance, regardless of the time, to neglect your dogs, correct?
Correct.
Yeah, that's why. So when I talk about the time not being relevant here, there is nothing offered as evidence so far, and I'll hear from the other side in a moment, suggesting in any way that these dogs were in harm's way or any way. Now, the other side may offer something and show that, but that's a heavy burden to show when food is being dropped off. The question becomes whether or not food being dropped off to dogs results in damage, and whether making a claim regarding a person neglecting dogs and a person not taking care of their property or anything else, whether or not that's an actionable claim before before this court and under Michigan law. That's really what this case is about. And I'll answer those questions as we come to that time. All right, so you indicated as part of your case that the dogs began to throw up. You indicated also that there was a visitation to a vet. Visitation to the vet was in regards to
I'm sorry, sir, your audio is breaking up a little bit towards the end. Can you repeat that?
All right, sorry about. Yeah, I was saying that you indicated that there was some visitation to the vet, and I was saying did that relate to both dogs?
Yes.
All right, and you can tell me about that, man. Tell me about the condition of the dogs during that time. Whatever you want to tell me about that. Go ahead.
Okay. They were very anxious during the trip to the vet and actually the interaction with the vet. The vet did suggest that I go to a specialist. I did not have the money at the time to take them to the specialist. I have scheduled an appointment for internal medicine for both dogs, which is scheduled for February 16th to confirm that they have sensitive stomachs, which I've had both of them since they were puppies and have delivered them. So I'm well aware of any physical ailments that they have. For the consultation fee for both animals, it's $224 per animal. For the ultrasound fee, it is $557 per animal. And this is with Blue Pearl. I do also have documentation from the AKC, where they're registered in regards to how a dog's food should be changed and some of the impact from that. I do also have the 911 audio recording from the wellness check on the 26th.
And Miss McGee does not dispute that the audio that a wellness check was made at that time. Is there anything in particular you wanted to tell me about that?
The claims that were made both the animal abuse call and the wellness check were both false. I have multiple witnesses that were speaking with. Oh, I'm sorry, there's an echo. Can you hear me okay, sir?
Yeah, I hear you. Go ahead, ma'am.
Okay. I have multiple witnesses that should be in the actual Zoom call that were aware of the interactions with my dogs. I also do have recordings from my anger management therapist and my psychiatrist in regards to the situation that occurred with Miss McGee.
All right, so tell me now how you may have been damaged by anything that was done regarding your dogs and anything that was said about whether or not you were caring for your dogs.
I was literally scared. I also have recordings from the Humane Society and Animal Control. I was considering putting down my animals because I was scared that someone was going to come back to hurt them. And then after the 911 call, I was literally scared to be at home. So I left the house. I stopped posting on social media for, I'd say, at least 26 days. There were only 8 people that I remain in contact with that I deem as my support system because I did not feel safe because of the actions that have been going on with my family. So this in turn stressed me out, increased my anxiety, increased my depression and my PTSD.
All right. Anything else you want to tell me this time?
I would also like to inquire in regards to the issue of perjury, because in our last court hearing, Ms. McGee advised that she did not pour any water on the floors, damaging my floors, which I do have video footage and still screenshots and recordings of her pouring 2 bottles of water on the floor, and there also being about a gallon of water being poured in the bowl and on the floor.
All right, ma'am. Anything else?
No, sir.
All right, thank you. Now, you did indicate to me it was not testimony at any previous occasion. There were statements made, and perjury occurs when a person is under oath and they make a false statement. That statement has to be material.
Okay.
So there's no claim for perjury on the statement that was made previously in this matter, because it wasn't, first of all, it wasn't under oath. But you did indicate to me on a previous occasion, but you need to put it under, while you're under oath now, that there was water spilled on the floor, and you indicated that there was some damage that occurred as a result of that. Tell me about that.
It's more so in the, I'm sorry, we're speaking to me? There's an echo.
Yeah, there is an echo, but I can hear you. I can hear you well. You indicated at the last hearing where there were statements made, no testimony was taken, but you indicated to me at the last hearing that due to the water spillage that it caused damage to a floor. That's and you haven't testified to that today. So tell me about that.
In the kitchen, there were several tiles that had to be pulled up because they started to lift about a day or so after, in regards to the amount of water that was poured on the floor. They're peel and stick tiles. The rest of the kitchen, she is not responsible for any of that damage, just the area that's by the kitchen window.
And I believe that you indicated that the combination of what it would take to repair that was a total of $150. Is that your testimony?
Yes, sir.
Now, as it relates to, and Ms. McGee will ask you, we'll have opportunity to ask you questions as well, but as it relates to the internal medicine appointments, et cetera, this is not something that has been done. This is something that you wish to do in the future. Is that correct?
Well, I was doing it as a result to provide proof to the court of the dog's ailments. I honestly already know what their ailments are. I've been taking care of them since they came out of the womb. So I'm very familiar with what their physical issues are. Another concern that I have also in regards to the wellness check was the things that were stated on the wellness check, stating that I had a pending felonious assault charge from May of 2022 with my ex-boyfriend, and also that I had a knife and a gun in the house, and I was in a crisis state, which I was not.
All right. Did you ever have a case or a case involving a felonious assault at any time?
Back in 2007, which was
that's a yes or no question. That's a yes or no question.
Okay. In regards to, can you repeat the question so I can make sure I'm hearing you correctly?
Did you have a case involving some claim or allegations of assault against a boyfriend or someone previously?
In 2022, no.
I didn't ask you in 2022, ma'am. I think that you heard the broad nature of my question. Answer my question.
Yes.
All right. And was that case resolved already?
Yes.
Okay. And the reason that I cut you off to ask the question in that way, because there are certain things persons cannot ask you about certain situations unless it involves theft or dishonesty. If there's a crime or something involving theft or dishonesty, then further questions can be asked. But if it's a different type of situation, like claims of felonious assault and so on and so forth, the question can be asked whether or not you face charges, and then the next question can be whether the case was resolved in some kind of way. Those are only two questions that can be asked you. That's why I stopped you from talking about it. Okay? Gotcha. All right. Ma'am, just one moment. Ma'am.
Excuse me, Your Honor. May I step away for just a second to grab my inhaler?
Just one moment. Okay. I'm looking at Kelly McGee. Ms. McGee, why are you here? Miss Paisley McGee, is Kelly McGee connected to your case? Is that a witness?
Correct.
All right. All right. So Miss Kelly McGee, I'm going to put you in a breakout room because you may offer testimony, and that's the way that we sequester you. So I'm gonna put you in a breakout room, and then we'll bring you back in at the right time, ma'am. So go ahead and click into the breakout room, Miss McGee, Miss Kelly McGee. Just one moment.
May I also have my witnesses sequestered as well?
I don't see your witnesses here, ma'am. They may be in a holding room or something, and if they are, they're in the proper place. Okay, Ms. McGee?
Yes.
Kelly McGee, yourself. I'm looking for Kelly McGee. Kelly McGee? Okay, I think that. All right, she went to the breakout room as I instructed. All right. Anything else, Miss Langford, please?
I do also have a current copy of my Michigan iChat background check, which shows that there are no current or pending felonies on my account, on my background check.
All right, ma'am. All right, anything else you want to tell me at this time? Let me ask you, did you spend any money at any veterinarian or anything like that, man? Talk to me.
No, I did not have the funds to take them. I did spend money on two shipped orders, which I ordered Pedialyte, chicken broth, rice, also Imodium AD, and a syringe, which those items were used to take care of the animals. I did send in a link to the photo evidence, which shows the first shipped. I'm sorry.
No, I don't need that. How much money did you spend on items that you purchased, that you just described to me, food and ammonium and a syringe? How much did you spend on that?
It looks like an estimated $83.
And that was back in June or July of 2002. 2022.
Yes, June.
June of 2000. All right, ma'am. All right, anything else you want to tell me at this time, ma'am?
No, sir.
One of the documents, you put a summary document, submitted a summary document to the court. You did not put you have not drove up to Michigan State or anything. Is that correct?
Yes, I did Friday.
All right. All right, thank you, ma'am. Anything else you want to tell me at this time before we may have questions for you, ma'am?
No, sir. May I step away for just a second to grab my inhaler, please?
Nora,
I'm sorry. And he can't hear you.
is that somebody, Sonora, that you know, ma'am?
Yes, that's actually one of my witnesses. The second one will be joining in just a second.
All right, thank you, Miss. Last name, Sonora, in this matter. I'm going to give you a notification for a breakout room, and I need you to go there, and I'll have you come out of there when it's time for you to testify. So just one moment, I'm going to make that happen. All right, so last name Sonora, if you'll go into that breakout room, and I'll get back to you when we call you up. Okay, very well. All right, go ahead, Miss Langford. You needed to do something, Miss Langford. Go ahead and take a moment, ma'am. At this point,
I'm back. My other witness, Lori Clark, should be joining in about a few minutes. She's currently at work.
all right, thank you, ma'am. So let me ask you, Ms. McGee, let me ask you if you have any questions for Ms. Langford at this time. Any questions you want to ask her relative to this matter, please?
No questions.
All right, thank you, ma'am. Now let me ask you, Miss Langford, the witnesses that you have indicated, Miss McGee, she's supposed to be in the breakout room, but she's back. But go ahead and tell me what that witness is offered for. Why are you offering that witness?
She's actually one of the individuals that is actually listed in my support system that can attest to my mental health conditions the day of the wellness check. Also, the conditions of my mental health the day of me leaving and returning to Chicago, as well as the care of my animals, and also some of the interactions that I've had with my family as a result of me posting my story on social media.
All right, now, and you're saying that that's the Sonora person, Indiana Sonora, is it?
Shanora Leckleitner?
All right, and is that person a doctor?
No.
She's not a psychiatrist, a psychologist?
No.
She couldn't testify as to your mental health.
Then my stepmother should not be allowed to testify because she is not my mental health advocate. She has not been to any of my therapy appointments or does not have any access to any of my medical records. She's never gone to any treatment with me. So I'm not understanding if she is allowed to be a witness, then she's not a physician and has not been participating in any of my mental health treatments. I don't understand why she's here.
Well, maybe you don't. And just like you don't understand why Sonora is here. Any person that's going to testify, any person that would like to testify to your mental health would have to be a person that is a licensed individual that could do that. It doesn't matter whether it's somebody that wants to testify against you or for you or whatever. They can't do that.
Correct.
Okay. So yeah, that's why I asked you about what she has to testify to. Miss McGee, before, that's why I asked whether that was Miss McGee's witness. Before her witness can testify, I'm going to ask her what that witness is intending to testify, because it may not be admissible. It doesn't matter who the witness is. So that testimony would not be admissible, and your testimony establishes that you take care of your dogs. There's no question about that. That's not a disputed issue here. So that witness doesn't have anything to offer in that regard. Now, is there something else that witness would be testifying to? Tell me about it.
Yes, she can also testify to my reaction and my response to the wellness check. In regards to, I'm sorry.
You've already testified to that. You've testified to your reaction. I don't need to hear from someone that's not an expert to tell me what your reaction is to the wellness check. You already provided testimony in that regard. All right. So what is the next witness that you had? You said you have a second witness that's calling in. What is that witness going to testify to?
In regards to the issues that we've had with the family and some of the things that have been going on. I can ask her not to join. She is also a part of my support system. The remaining portion of the family that I've actually encountered, she was also the individual, her and her brother were the individuals that came to my home during the wellness check. So I don't know if you want them to come or not.
Well, it's not a matter of what I want or don't want, it's a matter of what is allowable as testimony and whether or not that testimony will be relevant to the outcome of this case. What is relevant to the outcome of this case is the testimony that you provided and any testimony, obviously, that experts may provide regarding any diminution in mental health or anything along those lines. Now, taking your statements, obviously, you can testify to things that without the presence of a healthcare provider, you can testify to what your treatment has been, you can testify to what your mental health position was at the time before this and what occurred after that. That's why I didn't interrupt on any of that, because no physician is in a position to give a better picture of what is going on with your mental health, except they have the expertise to say, to give a diagnosis, give a prognosis, things along those lines. But other people are not in a position to do that. So I don't see where those witnesses would be able to offer testimony in this matter. Number one, that would be admissible, and number two, that would be relevant to the proceedings. And for that reason, I'm not going to allow those witnesses to testify in this matter.
Okay.
Sorry. All right, let me go to Ms. McGee. Ms. McGee, you said you had a person that you were offering that was going to testify at some point, Kelly McGee. What was likely to be her testimony? What is she intending to talk about?
This was just her testifying about, because the first hearing I had the advocate, but that got dismissed. So she's just here to advocate that she was on the phone call when we called and did the mental health check and wellness of the nature of her mental health. And the second part was the history of the dogs and things of that nature. So I guess she's for two reasonings.
What was she know or have to offer regarding the history of the dog? Has she interacted with the dogs?
No, the dogs already being sick prior. And then also her the plaintiff admitted to saying she was already going to surrender her dogs even before the incident on June 19th.
All right, her testimony will be allowed for the limited purpose of providing any information that she may have relative to the claim regarding the dogs and the claim regarding the phone call. Testimony relevant in that regard to anything that has to do with any mental health or anything along those lines. She can't testify.
Okay.
Testify. So I'll make that clear to her as she's called up to testify. All right. Any further? You said you had no questions of Ms. Langford. All right. So now the plaintiff's case is at rest now. That means that Ms. McGee, you have the opportunity to make an opening statement now to present, to give a summary of what you believe that your case will show, and so we can make an opening statement at this time.
Okay, sure. So let me go from the beginning. So again, I do agree that.
Right, just a moment. This is just a summary of what you believe the case will show, and then you will begin to talk about what this case is about. But just a summary. This is not testimony. All right, go ahead.
Yep. Okay. To summarize, there was a mental health call made, and there was also a wellness check made, and there was also wellness on the dog's behalf because of history with her daughter, which is also my cousin, had made us aware prior that when our cousin have episodes that the dogs get neglected. So when I went over to the house on June 19th and I fed the dogs, I did prior research beforehand, which I already submitted to the court as evidence of that, how I decided to feed them. And as well as I had 2 bowls. It was one with water and one with food, and they were placed down. And when I poured the water in and said I was pouring it on the floor, the bowl was already on the ground. So it wasn't going initially to the floor. I also presented evidence to the court about the wet floors because she submitted a video the next day, June 20th, to me. And that evidence is just showing the nature and how is minor water on the floor. And she also said she was going to mop the floor. And then I also submitted evidence to the court already of just showing that the dogs were already sick prior. There was damages that she mentioned prior. I also submitted the recorded phone call from June 19th after I left her premises when she said she does not want me to feed the dog. And that phone conversation got recorded, and it was brought up that she had prior damages to other people in that house. And also I fed the dogs and she was okay with that. And we just had a conversation. I presented a lot of evidence showing first off intent, the minor wet floors that she also admitted to mopping, which I mentioned in the last hearing, and damages before June 19th and damages afterwards where she mentioned doing multiple renovations. I submitted that to the court as well, videos and Facebook or social media postings where there's renovations happening ongoing in the house and her mentioning the house is uninhabitable. But yeah, just the dogs already being sick prior and vomiting a month before I even went over to the house. So the dogs already had history of vomiting. So I think that's my statement, intent, and yeah.
All right, so go ahead now with the testimony that you wish to offer regarding this matter. Basically, ma'am, it seems that the claims that are brought before the court is that the dogs that you came onto the premises without permission to do so, and that you engaged in feeding the dogs without permission to do so, and that as a result of that, the claim is that the dogs were made ill and that treatment was required. And then secondly, the claim is that reports were made to the police and that those reports were false and that they were malicious. And then finally, that it seems that there is a claim that the dogs require future treatment. And moreover, Ms. Langford has indicated that the conditions or what occurred here resulted in a trigger that increased some mental health challenges that she was dealing with. So tell me what your testimony is in this regard.
Okay, to acknowledge the first claim of being on the premises, there was June 18th, there was a wellness check call. And then June 19th, when I called, I basically said that my cousin had mental health concerns and I'm aware of history if she had episodes. The dogs are not well and they get neglected. So I asked for animal control's number. The police didn't come out June 19th. The police came out June 18th. Like I said, the last hearing, the advocate was able to show up. She can't right now. She's at work. However, I did submit to the court all of the text messages and she is a mental health professional. And I also had her father and her stepmother involved, which is Kelly McGee. So I did do the proper research. I did not have malicious intent. And the reason for this is because of all of the posting that I can submit to the court too, if necessary, about just the violent behavior, contemplating using a gun on her daughter, a lot of just very violent postings and outbursts, her driving past my mom's house, just behavioral things. That's the intent. So it wasn't malicious intent. The second one is falsifying a police report.
Just a moment, because there is a question. Just a couple of and they may drive questions that Ms. Langford may have at a certain point. I
Sure.
wanna make sure
Mhm.
You said, because I haven't delved into this, you're not an expert, you said that there is a history, that Mrs. Langford has a history of mental health challenges, is that correct?
That's right.
Are you familiar with the concept of decompensation?
No.
It generally describes where a person, and not to say Ms. Langford, but just so I can ask my question, where a person that has had mental health challenges and they are stable, they're living their life, and then
Mhm.
and then there are behaviors or actions or statements that show that
Mhm.
that they're starting to decompensate or starting to go back to a less
Decline.
mental state.
Mhm.
Is that what you said, that you were seeing something that you thought was decompensation, correct? Or
That's
decline?
correct.
And so the stuff that you're telling me about Facebook posts and things like that, they happened
Mhm.
around the June 18th time. Is that what you're saying?
They happen between April, May, and then June. So violent threats, saying how she contemplated using a gun in a closet on her daughter when they had a assault that happened in May, Breonna Jackson McGee. So like I said, it's a family matter, it's a sensitive matter, but like you said, there was a decline in the mental health, and then also her threatening her ex-boyfriend, putting up videos to say she's driving by his family house and she's not going to hurt him. She'll hurt the other family members. There's just a lot of violence. So, mhm,
Right. You said that this information, you were able to see it in some Facebook and type of things, and it happened
right.
in June. Is that correct?
Some in May, some in June. That's correct.
And that's why you're saying that that's why you were prompted to go to make the claims regarding wellness as well as to go over and feed the dogs, correct?
That's right.
Go ahead.
Absolutely.
You may continue.
Okay. So to answer the second claim, it says report to the police and falsify. Um, I was under the impression that because when I also called, I said that she had mental health and she had episodes, and knowing of history of, the dogs not being fed or like fed or neglected. It did come to me third party. At the last hearing, I had Asia McGee, which is my sister. She was with us when Breonna Jackson McGee, plaintiff's daughter, told us the history of how the dogs are treated. So I just mentioned that during the 911 call on June 19th to get the referral number for the animal control. So I feel like I didn't falsify. Um, and that's my stance on that, just
But
explaining the history. Mm-hmm.
your testimony that whatever you told
Mm-hmm.
animal control or law
Mm-hmm.
enforcement was related to information that you received from her other family members regarding previous episodes. Is that what you're saying?
Right, her daughter. If she have episodes or behavioral episodes, that she'll leave for long periods of time, whether it was the ex-boyfriend house, whether it was out of town, or just going to different friends' house. Mm-hmm. Okay.
Let me stop you.
Mm-hmm.
I can't let you get into what they may have said. The
Mm-hmm.
only question I was asking you about was
Mm-hmm.
any statements that you made. It sounded, what you're telling me is that if you made those statements to animal control or the police, it was based
Mm-hmm.
upon what her daughter or other family members had communicated to you about the care of adults, correct?
That's correct.
I can't let you get into what they may have told you because that would be hearsay. Just whatever they
Right.
told you, you used that as a part of the reason why you contacted animal control, correct?
Right.
All right, you may continue now.
Okay. And then to acknowledge, I believe I didn't hear this brought up from you out of the claims, but the damage of the floors. I could speak to that. I already submitted evidence to the court prior. This was on the 20th. I submitted a video showing her coming back home June. She said she came back June 19th. However, the video was June 20th that was sent to me showing the floors and how she was going to met it. How she was going to mop it because it had wet paw prints on the ground. But in the video, you see that there is no severe damage of it seeping through the floors. It was just minor wetness to the floor and like muddy paw prints. That was, yeah, like I said, January 20th. I sent that evidence and it's titled Mop Floors. So I'm just attesting that when I poured the water into the window, I just poured it into the bowl of water to speak to that claim.
Mhm.
Mhm.
Let me ask you this.
Okay.
You're testifying here that you received a call on the 20th of June or contact on the 20th of June. You don't know exactly when Ms. Langford returned home. Is that correct?
That's correct.
All right, anything else you want to tell me? Go ahead, ma'am.
Yeah. I also submitted, like I said, to the court, the recorded phone call from June 19th between Ms. Langford and I, as well as the screenshot of the timestamp of the time of when we spoke to the court. And basically in that call, I was there on the premises. She saw me on the ring footage, giving them food and water. And she said she was going to unblock me and we could have a phone conversation. We spoke on the matters of like the family being concerned of her mental health. And instead of going through other people, why won't people call her? And I just pretty much explained, because of her reactions, people feel like they can't get through to her. And I told her I did feed them, I gave them water, and it was out of pure concern. And then she also mentioned that her daughter's girlfriend and her daughter's ex-boyfriend already damaged the home, had multiple damages to the home. And I submitted that to the court. And I also submitted to the court the videos that she made on June 20th that was sent directly to me of her just speaking of me having the purest intention. And then speaking to the dogs already being sick on probiotics, and they haven't thrown up a month before this, until like before June 19th. They haven't thrown up before this. The time frame she gave, it was a month. She said between a month or 2 months, they haven't been throwing up. So they already was previously throwing up and previously on probiotics is what she was alluding to in the video that I submitted to court too.
And that was from, you testified that was from the 20th of June, right?
Right, correct.
All right, anything else you want to tell me at this time?
She spoke on, and then the last claim, the further treatment and her condition triggering her mental health. I understand that this could be also traumatic in the sense that I came to the home and they, allegedly was sick to it. But we also had the conversation June 19th, and it was a very peaceful, amicable conversation, phone recording. Like I said, that I submitted to court. It was very a peaceful conversation, and we left off at there. And then June 20th is when it ignited. She sent a big group text message of 16 people out of nowhere, just blasting and saying like I pretty much essentially poisoned her dog. So I feel like it's more manipulative and retaliation, especially if we had the prior conversation and then now she's having a totally different reaction and blasting it to everyone and putting it all on social media. I feel like part of it is malicious intent on her behalf more so. So to me, yes, it could be triggering, but I also think that she's using that too to be calculative and manipulative. And it's resulting in suing for $25,000. And I also submitted to the court of her retaliating with her ex suing for $2 million. So it's a pattern behavior of if she gets.
Let me stop you for a moment. I can't take any of that into consideration in regard to.
Okay.
Right.
Okay.
So I will not, I don't want to really.
Okay.
Because I will not. This case is the isolated case that stands on whatever this.
Okay.
Is. I will address that issue. All right, ma'am, go ahead. Anything else?
Okay. I believe, yeah, I believe, oh, and like I said, I submitted to the court the damages prior to, multiple videos prior to June 19th, where she mentioned her daughter, the ex-boyfriend, and the daughter's current girlfriend made multiple damages of the house. And I submitted that to the court January 21st, multiple. And then I also did submitted the videos of footage of her admitting to doing renovation even afterwards to the house, multiple renovations, staples, floors, all state claims in the front of the house, dumpsters and cleaning and multiple renovations. And I submitted that to the court as well.
Thank you, ma'am. Anything else?
I think that's it.
All right, thank you very much, ma'am. Any questions, Ms. Langford, that you wish to ask Ms. McGee at this time?
Yes. Did you see the ring footage of the initial altercation between Brianna and I from April?
I saw the ring footage that was posted online.
I'm asking, did you specifically see the ring footage that was posted in regards to the situation that you are referring to that occurred on April 22nd with Brianna Jackson McGee? It's a yes or no question.
I just answered.
And your
Okay.
answer again, ma'am, on that question was, what was your answer, Ms. McGee?
Yes, I saw the ring footage that was posted online.
And that judge, I specifically asked about the ring footage that was posted from April 22nd, 2002 that she's referring to with the misdemeanor regarding my daughter.
She says she saw it. Go ahead.
Right,
Okay.
I said it.
I was
Yeah.
making sure it's that specific date. Okay. Okay. In regards to the renovations that were done to the home, was this not a culmination of damages that were done from multiple parties?
To the best of your knowledge, if you know that answer, ma'am. The question Ms. Langford is asking is, if you know, I mean, because the nature of the question, she says the repairs and the corrections done to the home was as a result of multiple persons that caused damage to her property. If you know that to be true, ma'am?
I don't know if that's true or not, or false, no.
Are you aware as to whether or not some persons may have caused damage to Ms. Langford's property?
Yes.
Okay. Go ahead, Ms. Langford.
Are the damages that were done to the property from those other individuals, are those in the same area or the different area from the property that you damaged?
form of the question is improper. I
Okay.
guess your input is, the damage that she's claiming as to, that you may have caused regarding this water, is that in a different area than any other damage that may have occurred by other people?
To clarify, it was not clarified at the time of the video. It only mentioned damage to the house and floors, but she didn't specify in the videos prior to June 19th where exactly on her floor.
All right, well, you've, I think that you know by way of the testimony thus far that Ms. Langford is claiming that the area where the dogs were, where the water was left, that area was damaged. Ms. Langford's question is that area, is that area distinct from other areas where there may have been damage?
Can you repeat the question?
Her question is that area where the water was left, is that area distinct from other areas where there may have been damage?
I'm not sure, Your Honor. The video that I,
Here's what she said. It's a straightforward question. I don't want to take a lot of time. She's saying,
Yeah.
You were talking about how the house was damaged in other ways by other people. She's saying, can you separate out the claim that she's making and the area and the floor that she's talking about? Is that area and floor separated or different from other areas?
Right. To answer the question, I'm not sure because the video footage from her mouth only spoke of damages or floors. She did not specify.
In the video that you're talking about, did the video pan the area where the damage was?
None of them, just very vaguely damages and floors.
Right.
To answer.
Video showed the area where the dogs were at the time that you may have visited the home.
Yes, I submitted the footage.
I'm not talking about what you submitted. I'm talking about, you said you saw a video that Ms. Langford was showing regarding damage. In that video, did she show the area where the dogs were?
Yes, I submitted that. Yep. She did.
And in showing the area where the dogs was, you know that she was referencing the floor there as an area where she claimed damages, correct, ma'am?
Can you repeat that? It kind of broke up.
In showing the area where the dogs were, you know that in showing the area, she was intending to demonstrate that there was some damage to a floor in that area, correct?
Correct.
All right, Ms. Langford, you may continue, ma'am.
Is there a current do not contact order with Brianna Jackson McGee in effect?
I am not aware.
When was the last time Brianna Jackson McGee was at my home?
I am not aware.
When did I move from Kenneth Walker's residence back to my home permanently?
I am not aware.
During the time that I was at Mr. Walker's home, which was for about 2.5 years, was Brianna responsible for taking care of the dogs and I was paying for the dog food?
I am not aware.
During that 90-minute conversation that we had after I spoke with you on the Ring camera, did you mention that you called animal control?
No.
So just to confirm, you did not mention that you called animal control during that conversation.
That's been asked and answered.
Okay.
Go ahead.
When was the last time that you and I spoke?
The prior year, 2021.
Does December sound correct?
Possibly.
Who have I been in constant communication with since I stopped talking to the greater majority of the family?
I am unaware.
If you were, okay. In the following text message on June 20th, when I discovered that Isis was sick, did you respond with the type of dog food that you had given them?
Yes, I did respond, and I submitted that to the court.
Your Honor, may I have that information forwarded to me, because I did not get a response from her that when I asked her about the dog food. I do have the text messages on my phone.
Well, I'm not gonna send anything. What dog?
Okay,
food did you-
that's fine.
What dog food did you feed? What food did you feed the dog?
Taste the Wild. And I submitted that to the court, the direct message, that's January 21st to the court. And also, the dog food post, is January 22nd that I submit to the court. And I just matched the same dog food that was part of her posting from May 29th, 2022.
Which category of Taste of the Wild dog food did you give them?
I will have to look back at the video to verify.
Are you aware that I changed their diet back in April as a result of their sensitive stomachs?
Can you repeat the question?
Are you aware that I changed their dog food back in April of 2022 because of sensitive stomachs?
I am not aware.
Have you taken any of my animals to any vet appointments?
No.
Did you state in your previous testimony that the dogs had not been vomiting a month or two prior to you coming to my home?
Repeat the question.
Did you state in any of
Mhm.
your testimony that the dogs had not been vomiting prior to a month prior to the feeding the dogs?
Pre-trial, is she speaking of?
No, just a few minutes ago.
Okay.
Her question is whether your testimony
Uh-huh.
is that the dogs had not been vomiting a month before the incident.
Correct. Until a month prior, correct. Mm-hmm.
Are you aware of the dogs vomiting since you fed them at any point?
Repeat the question.
Since the time that you were informed that the dogs were vomiting as a result of food, after the food was fed to them, since that time, since that incident, have you heard of, have any reason to hear of the dogs vomiting?
No.
Are you aware of any mental health services or therapy services that I was seeking from April 2022 up until September 2022?
No.
Were you a part of any mental health services from my treatment plan from April 2022 to September 2022?
No.
Are you aware of any partial hospitalizations that occurred in May of 2022 as a result of an assault?
Yes.
Which hospital was that partial hospitalization taking place at?
Unsure of the hospital.
So just to confirm, you are aware that I was seeking mental health services during that time, correct?
Yes.
How many times was I in therapy per week?
Unsure.
If there is a current do not contact order in regards to the pending assault, how would Brianna Jackson McGee have knowledge of how the animals are being taken care of if she's not in the home?
Can you repeat that question?
Yeah,
If
yeah.
Brianna Jackson, I'm sorry,
Uh-huh.
I can't hear you, sir.
You gotta reform that question.
Okay.
That's a highly speculative, cause for speculation.
Who advised you that the dogs were being neglected?
Brianna McGee.
If Brianna Jackson McGee has not been in, I'm sorry.
Let me stop
I'm
you,
sorry.
but you can't
Okay.
ask a question like that.
Okay.
Here's what I think you're trying to get at. You may be able to ask this question. If, do you have any idea how Brianna would be aware of the condition of the dogs if she and I were not in contact during the time? Is that the question you want to ask?
Yes, sir.
All right, did
Thank
you
you.
understand the question, Ms. McGee?
Okay, now the way you reframed it, yeah. Yes. This was prior to June 19th is when I was made aware of the neglect by Brianna McGee verbally
I guess our
in person.
do you know how, Ms. McGee would have, is it Brianna McGee?
Right. Uh-huh.
Do you have any idea how Ms. Brianna McGee might have
Mhm.
known the information that she provided to you?
Because she was living there at the time when she reported, well, when it was told to me. She was living there, and then there was an incident, and then she moved back into the home. So the moving back into the home is when she acknowledged the neglect.
Were you provide?
Mhm.
Sorry,
Go ahead,
Were
ma'am.
you provided this information before or after the do not contact order was set in place by 36th District Court?
I'm not aware of the do not contact order, so I'm not aware of the date. Is this question, just to clarify, is this question about timing?
You answered the question there.
Okay, thank you.
Go ahead, and the next question.
How many times have I contacted the prosecutor or the Detroit police regarding Brianna Jackson McGee violating that do not contact order?
I'm not aware.
How many times have I advised Asia McGee to stop contacting me?
Repeat the question.
How many times has she advised Asia McGee to stop contacting her?
I'm not familiar. I'm not sure.
How many times have I asked Asia McGee to stay off of my husband's social media profile?
I'm only aware of one incident.
If I'm already, let me rephrase the question. Have you ever contacted any of my psychiatrists or clinical counselors regarding your concerns?
No, I don't know them. No.
How many times have I offered to go to group therapy with the family?
Once after our pretrial.
In the video posted on June 20th at 5:30 a.m. or 5:33 a.m., was there a comment that I made stating for us to go to family therapy?
January 18th, yes. Of this year, excuse me, of 2023, yes.
Okay. Excuse me, Your Honor, give me just a second.
Yes, ma'am.
Is there, I'm sorry, give me just a second. Need to get my thoughts together.
That's all right.
If you are aware that mental health services are already being sought, why would you call for a wellness check?
To answer based off of the postings and how violent they were becoming at a rapid speed daily is why I did my own proper professional advocacy work and research to make sure we try to help and provide the necessary steps for you.
If you are not aware of an existing treatment plan, oh, wait, let me back up. The person the person that you contacted regarding the advocacy services, are they active or were they active in any of my mental health treatment plans?
Not active in your treatment plan because I didn't know yours existed, so no.
Are you aware of the multiple therapies that I was engaging in from April of 2022 to September of 2022?
I think I already answered that. Aware of your mental health or your part of your treatment plan, April 2022 and September. I answered no to both. No.
Actually, no, that's a different question.
Yeah, but that question leads to the same conclusion. She's not
Okay.
aware and not engaged.
I'm not aware.
Amount of therapy or nature you have been involved in. That's the reason why we move on to the next question.
Okay. When was the last time that you've been inside my home?
I believe 2021, possibly.
Where was I living prior to here?
You were back and forth between your ex Ken house and your home.
Let's see. How much water does it, have you ever laid peel and stick flooring?
No.
Have you ever removed peel and stick flooring?
Yes.
Are you aware of the amount of water it would take for peel and stick flooring to lift?
I'm not aware.
When you arrived to my property on the 19th, did you have to push open the windows?
Pushed it up further. Yes, I had to push it up further.
When you say push it up further, are you referring to the screen or the window?
I think the actual window. I believe it was the window.
Were there locks on the windows?
Yes, I remember. Yep.
What is the definition of negligence?
Calls for a legal conclusion, ma'am.
Okay.
And,
I think that's all the questions I have.
Just 1 second. Ms. McGee, let me ask you, you indicated, and this may trigger other questions, you indicated that you selected food that you brought to the dogs, and you indicated when asked questions by Ms. Langford that this was, the food of choice was something that you had seen in a posting or something?
Correct.
What posting were you talking about? Was that something that Ms. Langford had posted?
Correct.
All right, and so you're saying that the decision for food that you made was based upon a food that she had identified on Facebook or on some type of social media post, correct?
That's correct.
Right, and you don't know whether or not she had changed from that food prior to you placing food at the home, or if it was the same food. You don't know, correct?
Correct.
But why did you use the food that she put out there on the social media posting?
The
Why did you choose-
food, uh-huh.
Yeah, why did you choose that particular food?
Okay, I thought I was interrupting, my bad. I chose that one in particular because that was the closest date next to June. That was May 29th, and this is a family matter. The last time, like Ms. Langford or the plaintiff was speaking of, last time we spoke was roughly maybe November, December 2021, estimated. We haven't spoke in between that time based off our own personal matters.
Okay,
So
what you were trying to do is you were trying to try your best, I guess, to use whatever food she might have been using.
that's right.
Okay, so you also stated that you consulted with some person regarding mental health issues. That person was not a part of Ms. Langford's treatment program or any treatment plan or modality that she might have been involved in. But you said you talked with someone to try to figure out the mental health pathway or something. Is that what you were saying?
Correct. So they gave me like different services, different like adult mental health, like crisis and facilities. She let me know like how we can go about just doing wellness checks and intervention. And like I said, she is licensed, she's social work, and she's also a mental health advocate. And like I said, she's currently at work right now, but she did show up pre-trial. So
she didn't have any paperwork on Miss Langford or anything, but based upon you believing that something was amiss, you spoke with her and she gave you information about how you might approach yourself. That's what you're saying, correct?
right, I took her on as like, well, they call it a hired advocate. Some say petitioners. However, we didn't petition her, so you know.
But you were thinking, I guess that triggers another question. So you thought that you might have to file a petition for hospitalization or something like that, correct?
Possibly if it was, but if the mental health decline or the behavioral, like the violent threats didn't stop online, eventually maybe, but it's a day by day thing, so.
But you never filed any petition for involuntary mental health commitment, correct?
No filing.
So what is your background, man? What do you do for a living?
What I do for a living, I'm an underwriter at a retirement plan company.
All right. So insurance type activity, correct?
Yeah.
Right. Any questions triggered by my questions, Ms. Langford?
Yes, sir. How many times in the last year, we'll say April of 2022 to September of 2022, have I voluntarily checked myself into COPE or any other psychiatric facility?
I think she answered that question. You didn't know, correct? Is that what you answered?
Yeah, she already asked me that about unsure which hospital in May 2022.
Okay. I'm sorry, I should rephrase the question. Have I ever checked myself in for psychiatric services? Period. No specific time frame.
Yes, I'm aware of you voluntarily checking in. Yes.
No other questions, Your Honor.
Thank you. Anything else you wanted to say at this time, Ms. Wood?
Just that I know it's a sensitive matter and I truly didn't have any malicious intent. Just family members being concerned about her mental health. That's it.
All right, come back. We'll come back to that. That sounds like
Okay.
closing.
Okay, closing. Okay.
Let me see if I can bring in the person in the breakout room. I don't know how much testimony is needed. But let's see. Do you know how to get this person out of the way?
You probably want to get your control.
I guess I
Can you send some?
can, that's what I was trying to see if I could send him something. But it doesn't look like it will let me check. I can just broadcast it, right? All right, Miss McGee, you can rejoin if you will, ma'am. Click into the main room. She heard me. All right, Miss Kelly McGee, you can come back into the courtroom. Just readmit yourself into the courtroom, please. All right, good morning to you, Ms. McGee.
Good morning.
And thank you for your patience in waiting in this regard. Let me have you raise your right hand to be sworn at this time, please. You do solemnly swear or affirm that the testimony you're about to give is the truth, so help you God.
I do.
All right, and you are, state your full name, if you will, for the record, please, ma'am.
Kelly Marie McGee.
All right, thank you, Ms. McGee. And Ms. McGee, you're called here to provide testimony regarding a matter in which Ms. Langford has brought an action against Ms. McGee regarding a mental health check and regarding a claim of filing false report, and also a claim regarding injury to personal property, animals, and water on the floor. What can you tell me about the incident that arose on or about the 18th of June of 2022? What do you know about that incident, ma'am?
On, I believe, this Saturday, so I think that was the 18th. Paisley McGee, myself, and William McGee, Miss Langford's father, went over to her home. We were in contact with a mental health advocate, and we were told that we should call the police also too, in this instance.
Let me stop you for just a moment. Okay.
Okay.
You can't tell someone else told you, so I can't, what that person told you, I can't take that into consideration. But it sounds like what you're telling me, though, is that after getting together with Miss Paisley McGee, with Miss Langford's father, and a mental health advocate, they gave you some information as to how you might want to react to things that you observed or that you heard, correct? Is that correct?
We were told how to proceed, and so we made the phone call to the police. They then came and went up to the house, and Miss Langford was not there. We left and returned later just ourselves. She hadn't returned, and that's all that happened that day.
All right, and how long after the police being there, how much time expired before the three of you came back the second time?
Approximately 2 to 3 hours.
All right, So what happens next, ma'am, if you know?
The next day, well, also in between that time, we noticed that she had posted videos on social media indicating that she was driving to Chicago for a Bridget.
Let me stop. I have to stop you because I may have to only hear testimony that's really on target
Okay.
here. You said we noticed. What did you notice, ma'am? Was there anything
Okay,
that you?
I saw a video of her online indicating that she was going to Chicago for a Bridgerton party, and she was also offering her tickets. Also, too, later that day, I saw a video of her where she had gotten her makeup done and she was dressed and stuff, so forth, for the party. The following day, there were videos of her posted, maybe not the following day. The next day, Paisley went to go feed the dogs because she wasn't home, to our knowledge. She fed the dogs, she gave them water, because she let me know she was doing that. On Monday,
I hate to, let me stop you. You did not go with Miss McGee to go feed the dogs, correct?
No, I did not.
All right, so the only thing that you would be able to tell me about that is something that she may have told you, correct?
I saw video evidence of it. I was on the phone at it during, a short period.
Okay, so you saw video evidence. Who showed the video evidence that you saw?
Miss Paisley showed video, and then later on Monday, Miss Langford posted video of Paisley being at her home.
Okay, all right, so that would have been the information that you saw directly. That would be the information that you saw directly. You were not there to see anything in person, correct?
No.
Okay, go ahead. You can tell me what else you wish to tell me at this time.
So on Monday, Miss Langford posted videos about her animals being ill and her taking them to the vet and whatnot. But I am aware of her dog, one of her dogs particularly being ill as far back as April. But she was saying, and she was very dramatic and crying and things like that, saying that her dogs were ill and stuff. Then she posted videos later saying that she might just surrender them or put them down and so forth. It's been a lot of videos, so it's hard to keep them all separate.
Okay, so when was the first time that you heard a discussion about the dogs being ill and placing them, maybe putting the dogs down? Was that before this incident with Miss Paisley McGee feeding the dogs? Did that occur before that time?
I heard of the dogs being ill all the way back in April. I was on the phone with her, and I then had a text from her saying that she had to go clean up poop and so forth.
All right, and what else? Anything else you want to bring to the court's attention at this time?
Just I do not feel in any type of way that Miss McGee would have tried to harm her animals. She was mostly, her concern was for their well-being. She called trying to get some assistance for them, and she was very adamant that she give them natural dog food and water. I'm not aware of her doing anything else. I don't believe that's something she would have done. I'm aware of the dogs being ill prior to this situation and there being damages to the floor and the house and whatnot prior to this incident. It's unfortunate that we're even here.
All right, and let me ask you, what is your relationship to Miss Paisley McGee?
I am our aunt and I am Ms. Langford's stepmother.
Well, you anticipated my next question. All right, got it. All right, ma'am. Anything else you want to tell me this time?
No, the whole issue was that we were concerned about Christelle and we were trying to get her some help because of things that have been going on with her video posting and phone conversations and whatnot that we've all had with her. Nobody had any malicious intent towards her that I'm aware of, or any malicious intent towards her animals.
All right, thank you, Ms. McGee. Ms. Langford, any questions that you wish to ask of Ms. Kelly McGee, please?
Yes. Are you aware of any of my current treatment plans or my treatments plans from April of 2022 to September of 2022?
I would not be able to be aware of that because you have blocked us from being able to talk to you and you have not shared that information. No.
Prior to you being, I'm sorry, go ahead.
So
I'm sorry, you
answer is-
just, okay.
Yes, our answer is no. You may continue, Ms. Lane.
Have you, Miss McGee, or Mr. William McGee ever been participants in any of my treatment plans?
That has nothing to do with that, but no, we have not been invited to do so until recently.
All right, well, Ms. McGee, you can't determine whether that has anything to do with it. But I
Okay.
think your answer to the question is no, correct?
No.
Go ahead, Ms. Lane.
Have you ever interacted with my animals?
Once.
Have you ever been responsible for taking care of my animals?
No.
Are you aware of a do not contact order with Brianna Jackson McGee?
No.
Are you aware of a motion that was filed for eviction for Brianna Jackson McGee back in April of 2022?
No.
When was the last time you or Mr. McGee have been to my home?
In June.
What year? Prior, with me actually being here, prior to the wellness check.
Shortly after you purchased the home. That I believe that maybe around Memorial Day, shortly after you purchased it. I don't remember the date.
2018 sound about correct?
Possibly. I'm not 100% sure of the date.
How are you supposed to change an animal's food?
If you know, ma'am.
I can't answer that. I don't know.
Are there any impacts of giving animals a different brand of food without it being gradually changed?
I couldn't speak on that. I don't know.
Were the wellness check calls made after I discovered the video footage of Paisley's initial arrival?
No, they were made, the initial one was made prior to, where I was present. It was prior to. And then your father and her came back on a separate occasion.
Excuse me, sorry. Who was responsible for the animals while I was living with Kenneth Walker?
I don't know.
What damage was done to the home by Brianna Jackson McGee?
I can't say specifically. You just said your house was a wreck. And that your that your house was a wreck. And you hadn't posted a video about fecal matter and stuff as far as your dogs. So I don't know who was responsible for that.
When was the, and I'm sorry, I'm just want to make, I don't remember if I asked this question. When was the last time Brianna was here in this home?
I don't know.
When was the last time you've talked to Brianna?
In April or May, April, I guess, when you guys came by our house. That's the last time I seen her or talked to her.
Okay.
April 22?
Yes.
What gave you the impression that the animals were being abused or neglected?
the fact that you were gone for a long period of time and just rumor.
Is it illegal to leave an animal or animals in the home longer than 24 hours?
Pause for a legal conclusion. I'm sorry, I can't let you ask that one.
I'm not a lawyer. I don't know.
That's why I'm here.
Let's see. Give me just a second. What was I doing on the morning of June 26th that was considered as violent?
You said on June 26th?
Yes, that was the date of the wellness call where the police officers actually came to my home and I was here.
To the best of your knowledge, Ms. McGee, for inquiry is. You understand the question?
It was based on all the videos and text messages and so forth that you had put out where people were concerned about you.
Did anyone reach out to Brianna Jackson McGee for my mental health professional's contact information?
Not to my knowledge. I don't even know if we have her phone number.
Did anyone speak with either Lori or Dwayne Clark for my mental health professional's contact information?
No.
Okay, how long was I gone?
From the timelines of the videos and things that you posted initially, it would seem like you were gone from Saturday until Monday morning.
Can you post videos or status updates online and they be a different time than when they actually occurred?
I suppose the question here is it in fact true that you can't always tell the time frame that may be involved based upon online postings? Is that correct, ma'am?
Yes.
I guess that could be true.
Have I ever checked myself into any mental health facilities over the last 3 years?
If you know, ma'am.
If you know.
I can only go by hearsay. I've never heard you directly say that you have. To us, no.
The video that you saved from this past weekend, entitled Receipts, what did you see in that video from TikTok?
You were showing, you called it receipts, but it was more so you speaking. You were flashing pieces of paper and things like that, and was supposed to be evidence, but you didn't leave them in a timely manner where they could be observed. You couldn't really look at them. And one video you put up indicating the time of day that you got home. You indicated that you got home at 12:30 in the a.m., but it was dark in the video, and so some things didn't mesh up.
Are you aware of how to pause, rewind, or fast forward on TikTok?
No. I don't care about it like that.
Obviously, you care enough to call the police. No other questions, Your Honor.
Thank you. Thank you, ma'am. All right, thank you, Ms. McGee, for your testimony in this matter. Let me ask you well, no, I'm gonna ask you that. Let me ask Miss Paisley McGee, and I had a question. When you went back to the home and to feed the dogs, was anyone with you at that time?
Yes, it was, my friend went with me.
So you and a friend?
Yes,
All right, thank you, ma'am. And what date was that on?
that was June 19th,
That would have been
a Sunday. Mm-hmm.
all right, ma'am. Thank you very much. Before we close out, I guess I do have another question.
Okay.
So the day before that, on that Saturday, you had gone to the property as well with Miss McGee, Miss Langford's father, and with Miss McGee, who just testified?
That's right.
All right. All right, thank you very much, Miss McGee. All right, it seems that the evidence in this matter is in, the testimony has been offered at this time. And so both parties having presented their evidence in this matter. The one thing that is allowed is what's called rebuttal evidence. And that's where the plaintiff has an opportunity, if there is something that you wish to offer as rebuttal evidence, you have the right to bring that to the court's attention if there's something that is a specific rebuttal to something that was offered that has not been covered before. And Ms. Langford, you have the opportunity to offer rebuttal before. This is not closing statement. This is just if you have something as rebuttal evidence on a particular point that was raised, you may do that at this time.
Sure. Your Honor, I do have all of my mental health medical records, which I can upload to the file share drive that I have. At that time, I was engaging in therapy with New Oakland Family Services and Motor City Center for Hope for anger management. Prior to that, in April, I was also a participant in domestic violence and sexual assault therapy with the Detroit Victims Assistance. Also, I did change their dog food in April once I moved back to my home because I saw how sick that it was making them and the fact that my daughter was not taking care of them. During that time, I was going to sell the home because of the damages that were done from the home from my daughter. I do have documentation of the damages that were done to my home by my daughter, which are not in relation to what Ms. McGee has done. I do also have documentation from the insurance company in regards to the damages that were done that I'm not holding Ms. McGee responsible for. I do have all of the social media videos that I have posted that I'm more than willing to upload to the court.
Thank you, ma'am.
No.
Miss McGee, do you have any dispute with Miss Langford's claim that she has been actively involved in mental health treatment?
Are you specifying timing or?
Yeah, during the time that's relevant to this case, I know you've already testified that what you saw on social media, what your discussions were with her daughter and with a mental health person led you to believe that there may have been something going on that Miss Langford may have suffered an episode. But do you have anything to suggest or do you have any evidence that would tell us that she was not involved in treatment? In other words, you don't know if she was seeing doctors or on a treatment program or seeing therapists at that time. You have no way
Right.
of knowing.
At that time, no.
And so if she was, you would know that, and if she wasn't, you wouldn't know that.
No, I only know after the incident of when she spoke with her therapist, and I can submit that to the court, and the therapist telling her that there was no harm or she was not going to report what I did, and 'cause that's all I have is after.
Is that something that, did you speak with the therapist?
She posted it on Facebook, so it's public knowledge, and I have that evidence. That's it.
All right, and so something that was posted on Facebook,
Mhm.
you were able to observe it, correct?
That's right.
And when you observed that, it led you to the conclusion that that someone that was part of her treatment concluded that there was no harm in this incident?
That's correct. I have that.
And you're aware that that person is not here to testify or anything, correct? You understand that, correct?
Correct.
You don't know whether that person was a psychiatrist or psychologist. You don't know what their status is. Is that true?
I just know she mentioned therapy session. So she said her therapist, and she wanted her therapist to report this. So she emphasized out of her mouth.
All right, thank you.
You're welcome.
Okay, Ms. Lightford, you may proceed with a closing statement, a summation of what you believe the case has shown, and you'll get the final word in this case. So the way it goes is that you give a summation of what you believe the case has shown. Ms. McGee will give a summary of what she believes the case has shown and what she's asking the court to do. Likely, Ms. Langford will be saying, will summarize what she believes the case has shown and tell me what she's asking me to do, asking for damages, whatever. Ms. McGee will likely give a summary of what she believes the case has shown, and she'll be asking, of course, that I dismiss the case or something along those lines. And then finally, Ms. Langford, I'll come back to you because you get the final word because of the burden of proof, and you'll be able to give your final response to whatever Ms. McGee may have said. So you get to give a closing statement. It's typically called initial closing statement. Then Ms. McGee gets to give her final word, final chance to say something, and then you get the final closing statement. All right. So you may proceed with your initial closing statement at this time, Ms. Langford.
Your Honor, there was a do not contact order that was entered into play on April 20th, 2022 by the 36th District Court, where I am not allowed to have any sort of contact with Breonna Jackson McGee. Once I came home from jail, I had my cousin Lori Clark confirm that Breonna was not here. Breonna has not been in my home since April 20th of 2022. There was also a letter of eviction filed for Breonna Jackson McGee. It essentially, all of the information that Miss McGee, and Mr. McGee are going on is hearsay. They have not been active in any of my treatment plans or any of my mental health services. They have not also been interacting with any of my animals. They are not aware of the intricacies of my animals' diet restrictions or how that could be impacted. They're also not aware of any of the conditions or damages of my home, seeing as they stated themselves that they have not been inside of the home for at least 6 months to longer. So essentially, all of the information that they are going on is based off of hearsay. As you heard Ms. McGee state, that I posted different documentation as far as stating where I was, etc., which she was unable to actually go through and review any of the footage, which includes mileage tracker apps, multiple purchase receipts from multiple stores in the state of Michigan, in Detroit, amongst other documentation stating my trip. So they assumed that I was gone for a long time and clearly admitted that those posts could have been made at a different date or time than what they saw them. So at this point, Judge, essentially the wellness checks and the animal cruelty calls were all out of speculation, and they weren't a part of any treatment plan and weren't aware of any type of medications or anything, or any of my own partial hospitalization programs that I was enrolled in at that time, which I do have all of the documentation and footage available for the court. Initially, I was under the impression that Miss McGee came to my home with good intentions. After reviewing all of the video footage, the initial video footage of her being here within less than 5 minutes, stating that she was going to call the police on me regarding abuse and neglect, is what changed my outlook and perspective. I have provided the court with all of my documentation. I can again also upload my medical records to the file share folder, which include all of the receipts, the video calls and audio recordings of me being on the line with not only my therapist, but also my psychologist after the wellness check that was done on 6/26. So I believe that I have met and exceeded my evidentiary burden.
All right, ma'am. Thank you very much, Ms. Langford. All right, Ms. McGee, you may give your final response or your final closing argument regarding this matter, ma'am. You may.
Sure. Let me address the do not contact order. I already admitted to the court as well as the plaintiff that I spoke with her daughter prior to April 20th, 22. So this was awareness from a party that lived in the house prior to the April incident of the physical assault with her daughter. I would also like to speak to intent of the violent threats and, the out of her own mouth of, being violent to others and, possibly being a danger to someone else if you're admitting to using other weapons and guns and even on your daughter. So as a family member, I did the proper research, as well as the dog food, did the proper research prior to, and not just went and just bought something. I tried to take as much prior knowledge from her, as well as getting professional mental health, a higher advocate, to know how to navigate this. Like I said, I wasn't speaking to her prior to it, possibly November, December 2021. So I wanted to make sure I went into it being delicate and also not being aware how to navigate mental health. I also wasn't malicious intent as well by putting her legal parents, living parents involved with this, initiating the wellness check, and also calling for animal control because of the prior knowledge that her daughter that lived with her gave me and my sister. And then just calling the cops to see how can I get this referral number. Just there was no malicious intent, just wellness. And I submitted that to the court of her just saying that I had pure intent. And just like she spoke on the matter, that her intentions changed when she heard involvement of cops and like animal control. So it became retaliation in my eyes, based off of the filing, and also as well as the how much she wants in damages. She wants 25,000. Like I said, I feel like that's retaliation, and I'm aware of the May 2022 hospitalization, and I did take that into consideration. However, there were still ongoing violent videos happen daily, if not every other day, where she was targeting different people out the family or her ex-boyfriend. So it was out of pure concern. And just like I mentioned, she posted on Facebook to her therapist. She got upset with the therapist because the therapist would not report me about abusing her mental health. And she got into it with the therapist as well. And this is just to show that, you know, I feel like a lot of times if she's interrupted or disrupted, there's retaliation that's faced, whether it's court or filings. You know, it's not that she can't exercise her right. I just feel like, you know, if you don't do what she wants you to do, then it's retaliation. So I feel like I proven myself and gave all the evidence as far as, you know, showing the floors and that is not the water didn't seep into her floor. I showed that in the multiple videos that she spoke on the house being damaged, as well as the recorded phone call, the damages, multiple damages of tearing up the whole house, she states. So, and she also mentioned prior to in her statements that, you know, there was other damages to the kitchen. So who's to say that there was not already prior damages to the floor in the kitchen, and me putting the water on there is just her saying, oh, I need to mop the floor. And that's what she stated in the video. She didn't state, oh, it seeped into my floors and now it's eroded. So she kind of admitted to that too, that there was already ongoing damages. She already was trying to sell the house. She mentioned the house having damages with the dogs, and like I gave the evidence to the court too of the house being uninhabitable, and those are words out of her mouth. So I think I presented a lot to the court, showing my intent, showing the wellness check, showing I did the proper educating myself with the mental health advocate, and yeah, and then, like I said, the damages. So I think that, you know, this is a family sensitive family matter, and hopefully it'll be done after this.
All right, thank you. Thank you very much, ma'am.
Mm-hmm.
And Miss Langford, you get the last word on this, ma'am.
Thank you. Your Honor, one of the things that I've noticed that have not been addressed by the other family members in regards to my behavior were the multiple instances of people coming to my home when I'm not home. As a homeowner and a pet owner, I have the legal right to say who can and cannot come to my house, who can and cannot come feed my animals or interact with my animals. I have made reports on multiple instances from April of 2022 up until September of 2022 of multiple people coming to my home, Miss McGee being one of them. I can, like I said, I can provide documentation where I was at that time in standard clinical therapy, CBT therapy, cognitive behavioral therapy, and also anger management. I then again also enrolled myself in the partial hospitalization program at New Oakland. I am a high functioning person with depression. Anytime that I have sought, if anytime that there has been any off behavior, I have reached out to multiple therapists. I have reached out to multiple support systems. I have checked myself in at least 4 to 5 times. I am very aware of my mental health status, and I've made sure to also inform my therapist and my psychiatrist in those instances regarding the situation that had happened. The reason why I was upset and chose another therapist was because I have showed her video evidence of multiple people coming to my home, including my own daughter assaulting me, which is now with the lawyer. I'm fighting that charge. So I have video documentation of people putting their hands on me. I have video documentation of people who have no interaction with my animals, feeding them a completely different type of dog food. They don't even know if I have changed that dog food since then. They have no knowledge of how I care for my animals. And they also have no knowledge of how I take care of my mental health. At this point, Your Honor, like I said, when I got the ring notification, responded to Paisley, I thought it was out of pure intent. Nowhere near in that 90-minute call that we had did she ever inform me that she was concerned about animal abuse and neglect. I provided her with documentation stating that I had just left the house a couple of hours before she got there. The information that they chose to act on was back from April. If Miss McGee, Miss Kelly McGee, and Mr. McGee were so concerned, why wasn't anyone contacted back in April? Brianna Jackson McGee has not been in my home since that do not contact order has been in effect. And I also made sure to contact not only the Wayne County prosecutor, but the Detroit police on the 12th precinct regarding her contacting me. If I have any contact with Brianna Jackson McGee, my personal bond is revoked. So how is it that they are aware of what's going on in my house? And the only one that is here is me and my animals. Your Honor, like I said, I initially thought that this was pure intent, but after reviewing the video footage, hearing the 911 calls where they're stating that I'm in a mental health crisis and I'm literally taking care of animals, going and traveling back and forth, making sure my animals are taken care of, this is malicious intent. If they have no knowledge of my treatment plan, and they're calling the Detroit police and stating that I am violent, I'm having a mental health crisis, and I have weapons in the home. And by so, the DPD responded with 6 police officers surrounding my home. They are additionally inflicting trauma on me, and they're not even aware of any of my mental health treatment plans. That's all I have to say, Your Honor. Thank you.
All right, thank you, Ms. Langford. And thank you, Ms. McGee. Thank you for the testimony and evidence offered in this matter. It certainly has given the court the bandwidth of information to consider in determining what the outcome of this case should be. I've looked at the items that have been otherwise submitted to the court, and basically the court has honed in on individuals telling their story. As is always a critical part of these kinds of things, is that nobody can tell the individual story better than they can. And being able to describe what happened, the nuances that are involved in what happened. And that's pretty much what has occurred in this case. There have been no mental health professionals that have been called as witnesses to testify in this matter. And so the court cannot make a determination regarding any person's mental health condition from a diagnosis and prognosis standpoint. I can make decisions and determinations on the evidence offered here regarding the history and the relevant time and condition that may have been in operation based upon the evidence that is offered by Ms. Langford, because she knows her mental health position and the history that is involved there. I can also derive conclusions from information that may have been exposed to Ms. McGee by virtue of Facebook postings or other information, not to diagnose any condition, but to determine whether or not anyone acted reasonably under the circumstances. And that's really what this case turns on. This case turns on how reasonable the action that was taken in this case is, and whether or not that action is reasonable is determinative to the outcome of this case. And if persons act reasonably, unfortunately, sometimes they can act. A person can act reasonably and still be wrong about the decision that they made, but they acted in a reasonable manner. And I'll get into that a little bit as we go through this case, because that's what this matter really turns on. It turns on the reasonableness of the actions and the behavior that was engaged in this particular case, and connected to how reasonable an action is has to do with what does a person stand to gain, or what is their benefit to being erred to them by virtue of action that is taken. For example, a person may take certain actions that will result in them getting a monetary advantage, or some type of political advantage, or some type of control. And the fact that they have a monetary outcome or some type of control outcome could mean that they have acted less than reasonably because they had a particular motive that they were trying to achieve that was to their pecuniary or other benefit. When there is not something to be gained, then the court has to look even more carefully at the motivation that was involved and whether or not the actions taken were reasonable, because then the person that took the action has nothing to gain except something that might inure to the benefit of the person that they sought to assist or be involved with. Those are the kind of considerations the court takes. Here's what I see after viewing all the evidence in this matter. First of all, the burden of proof continues and always rests with the plaintiff. The plaintiff has to ponderate by showing that there is more evidence against, or strike that more evidence in favor of the proposition that she raises before the court, as opposed to any evidence that may be against that. If the evidence is even, then the plaintiff loses. The plaintiff always has to tilt the scale. And so if I put my hands before you just to as a way of describing what the burden of proof is about, you oftentimes hear in a criminal case that the burden of proof is beyond a reasonable doubt. So in a criminal case, the burden of proof, if you start out with the hands even, in a criminal case, the burden of proof is like that. You got to have proof beyond a reasonable doubt. In a civil case, if you assume the hands are even, you talk about proof by a preponderance. And proof by a preponderance means that the scale has to be tilted. Scale has to be tilted. It has to be tilted in favor of the proposition. Doesn't have to be that much. Doesn't have to be that much. It just has to tilt the scale. That tilting of the scale means that if the evidence is even or if the evidence is clear, it means that the plaintiff does not carry the burden. If there is enough evidence supporting the proposition, it means that the plaintiff tilts the scale and the plaintiff carries the burden. The only way the plaintiff could recover anything is if the plaintiff tilts the scale. All right, so in looking at the evidence, offered in this case, what this case is about is some decisions that were made by multiple persons, but that comes to a cause of action brought against the defendant in this matter, Ms. McGee. For sure, Ms. Paisley McGee, as well as the other Ms. McGee that testified today, as well as Mr. McGee, who is the father of Ms. Langford, all came to the property on the 18th of June of 2022. Because there was a conclusion drawn that was shared by the three of them that Ms. Langford may be experiencing a crisis. It is undisputed in the context of this hearing, especially by virtue of the testimony of Ms. Langford, that Ms. Langford has been forthright and honest about the reality that she has experienced some mental health challenges and has checked herself in and has accessed mental health assistance in her mental health journey. None of those are things that can be held against a person. That is a part of life, that some people suffer challenges that require that they participate in an ongoing modality of treatment. And Ms. Langford has been straightforward about the fact that she has had scenarios where she has sought and received treatment, and I believe she's testified that she continued to do so up to this present time. With that in mind, the Ms. Paisley, Ms. McGee and Mr. McGee went to the home to do a wellness check. Subsequent to that initial wellness check, Ms. McGee and another person returned to the home on the same day, and there's no evidence as to anything that happened or occurred at that time. And then on the 19th of June is when Ms. Paisley McGee returns to the home that is owned and occupied on Pinehurst Street by Ms. Langford. And they arrive at the home, and Ms. McGee has a specific purpose in mind, and that is to provide care to dogs that she believes may be in distress, because she has come to believe that Ms. Langford may be having a mental health episode. Her basis for that is rooted in statements that were made to her that are not in evidence here, that she indicates in her communications with Ms. McGee's, with Ms. Langford's daughter, that she had cause to believe that Ms. Langford may be in some harm position. The more significant for Ms. McGee was the fact that she had observed multiple and progressive social media posts that she believed to be of a threatening nature, that was talking about the use of weapons and threatening it as attacks against an ex-boyfriend and otherwise, that the post appeared to be threatening. That was also the testimony of the other Ms. McGee that testified in this matter, that she was aware of the social media posts that gave rise to the conclusion that Ms. Langford may have been having a psychiatric episode, and that a wellness check may have been something that was in order. So Miss McGee, that is Miss Paisley McGee, made contact with a mental health professional and made inquiries as to how she might go about approaching the situation if Miss Langford was having a mental health episode. The parties have been replete in letting me know that Miss Langford had, on a previous occasion before any of these incidents occurred, had blocked most family members from making any contact with her, and so that they would have the inability to reach out directly to her because of the fact that she had blocked them from having any contact with her. It was also known to the parties involved herein that Ms. Langford did not want them to come to her home or to her property. And that was a part of the reason that she had blocked folks from being connected to her. But the issue becomes where there are family members or persons who are connected, or even friends that may have reasonably believe that the plaintiff in this matter, Ms. Langford, is suffering with a mental health episode, whether or not they could use such information to draw a reasonable conclusion that maybe they should take some action. And what occurred here is that there was a reasonable conclusion that was drawn. The court would have to find it was reasonable, even though none of these persons were involved in Miss Langford's mental health support system. None of them were involved in any direct determination by psychiatrists or psychologists, but they all were able to observe the posts that were made on social media, and also the posts regarding violence, and the postings that were made relative to her being away from the premises. There is nothing on this record that establishes that Ms. Langford took a long stay away from the premises. Although prior to coming to the premises, the parties were not able to know that for certain. They were using that information together with the information regarding the social media posts and the information that sounded violent in nature. They were using that as a basis to say, well, is there something wrong here? And if there is something wrong, what action should be taken? Before any action was taken, there was contact with a professional that was able to give some information to Ms. McGee regarding various steps that could be taken. Ms. McGee concluded from that that she could engage law enforcement services, that she could go over and do a wellness check, and that if she felt that the animals were in distress, that it would not be unreasonable to go over and try to provide some level of care to the animals. So that what happened here? The defendant in this matter made contact with law enforcement, made contact with the veterinarian society, claiming that there may be that the animals, the dogs, may be in distress, and she went to the property. She went to the property on 3 different occasions. The 2 occasions would seem to be to check for wellness and to determine whether or not Ms. Langford is at the property. On those occasions, Ms. Langford was not there, and there was no ability to check her whereabouts and know what her condition was. A day after that, Miss McGee went to the property and made entry into the property. I believe the testimony here is that a window was open for purposes of going into the property to make contact with the animals that were in the property. The action that she took when going in was to provide food to the animals and to provide water. She reasonably believed, or in her estimation, she reasonably believed that the animals may have been in distress. She was not absolutely sure, but she had come to the home twice in a 24-hour period, and she had considered the social media post and the information provided to her by the healthcare professional. In addition to that, Ms. McGee looked online to see if there was posting of information regarding the type of food that was fed to the animals, so that if she was going to feed the animals, she looked to what had been provided by Ms. Langford regarding what Ms. Langford fed the animals. That information was dated in April of 2022. And there, from the testimony, I did not receive any information that there was any posting regarding any changes in what the animals were eating. Ms. Langford did testify that sometime after that April period that she had in fact changed the animals' food supply because they had weak stomachs. That information was not information that was known to Ms. McGee. So Ms. McGee acted on the best information that she had available to her, given that there was no other information that had been posted to the contrary. So when I look at this case, the case centers around whether or not Ms. McGee's actions that were taken were reasonable. Certainly, this was not an action that was taken that was of a criminal nature. So that the question that we look to is whether or not it was of some type of negligent nature as to what may occur. What occurred in this case, then what the court has to look to then is a standard of reasonableness. What would a reasonable person do under circumstances where they have a family member that they have formed a belief that this person may be suffering with a mental health episode? They've gone to the property twice. They received some information from the plaintiff's daughter, the daughter which the plaintiff was out of relationship with. The plaintiff had made it very clear to the court that there was a no contact provision in a bond, and that her daughter was not in contact with her, and she was not in contact with her daughter. And she argued that her daughter would not be able to be aware of the exact circumstances of her life. That testimony would seem to bear some truth. What it seems is that the daughter was able to give some information about what may have happened in the past regarding when Ms. Langford had an episode or decompensated from a mental health standpoint. Being armed with some information, Ms. McGee made the decision that looking after the dogs or trying to provide care for the dogs and notifying the Humane Society that these might be decisions that would need to be made in an effort to make sure that the dogs were taken care of. Under the circumstances where there is some evidence that the defendant, that the plaintiff is having some issues with violence on the social media posting, some information that suggests that she may not be at the home and that the dogs are there. I cannot find that it is unreasonable that Ms. McGee would then, as a family member, go to the home in an effort to feed the dogs. Moreover, that does not seem to be something that in a later conversation that was had with Ms. Langford, that Ms. Langford found to be unreasonable. What became the rub in this situation is when Ms. Langford discovered that the dogs were throwing up, that they seemed to be having something of an episode as a result of having been fed. And subsequent to that time, she did take the dogs to the vet. There was not a bill generated for that. There was not a medical diagnosis, if you will, that is associated to this incident that was made in that regard. Ms. McGee Ms. Langford has testified that her dogs have a weak stomach, that the change in the dog food from what was on social media to what she had changed the food to, but that going back to food that had been previously offered to the dogs, she believed that that caused them to have sickness. There is testimony in this record by Miss McGee, both Miss McGee's, that the dog had been ill on previous occasions, a month or so before this incident ever occurred. But here's the thing, the heart of this is, you know, I could look at it and say, well, you know, there's some evidence that the dogs were sick before. Now, then the dogs eat this food, and then they're throwing up in this incident. Miss Langford was forthright in saying that her dogs had medical conditions, and she's aware of the conditions that they had. Now, what she wants to do is approximately 6 or 7 months later, she wants to take them to Michigan State so that they can be evaluated to relate the incident to any health problems that the dogs may have at this point. That's unreasonable. All of that is unreasonable. What's reasonable here is that Miss McGee came to the property, made the decision out of an abundance of caution that the dogs may need to be fed, and didn't just go to the store and get some alcohol. She decided that she would look at the social media post and determine what does she feed her dogs. And she used the best information available to her to feed the dogs with what Miss McGee was feeding, that Miss Langston was, Langford was feeding the dogs with. That is not unreasonable. That, and what the court has to assess here is reasonableness. That is not unreasonable to use this circumstance where there seems to be some mental health episode, although ultimately that proves to not be true. It does not seem as if in the aftermath that there was a mental health episode that was occurring. But if a person acts reasonably, it doesn't matter whether or not their reasonable belief turns out to be wrong. That doesn't matter. If they made a reasonable decision, it doesn't matter that they turn out to be wrong. For example, if you reasonably believe that someone is breaking into your home because they are at your window and they seem to be doing something at your window, and you reasonably believe that they're breaking in, and you fire a shot and that person dies dead, you were mistaken. They were at your window because they were whatever. Let's make up something. They were at your window for some reason that might have been justified. They saw someone else trying to break in, and they forced that person away from your window, and they happen to be standing there, and you shoot and kill them. Well, you made a mistake, but you reasonably believe, that's a crazy example to use, but you reasonably believe that that person might have been breaking into your house, and you get away with shooting someone and causing their death because there was a reasonable belief. The circumstances here provide a reasonable belief that something was wrong. And then we look at the steps that were taken. If what happens here is Miss McGee comes to the home, removes the dogs from the home, takes the dogs to the Humane Society, et cetera, those steps would not be reasonable here. Because when she comes into the home, she has the opportunity to provide some food, provide some water. Now she decides that she's going to take the dogs, take them to the dog pound, turn the dogs in, and turn the dogs over for the dogs to be put to sleep, and so on and so forth. That's unreasonable. Feeding the dogs with a dog brand that had been identified by Ms. Langford on social media, not unreasonable. And if she happens to be if she happens to be wrong, that does not give rise to liability for harm that may have occurred unintentionally in relationship to feeding the dogs with food that had previously been posted by Ms. Langford. Moreover, in this case, the evidence supports that these dogs were dealing with some health issues prior to this time. And in the testimony that's been offered by Ms. Langford, that the dogs went to the veterinarian, that the dogs have been had done well since going to the veterinarian, that she spent some money to bring them to back to a certain level of health. She indicated to me that she spent something in the nature of $85 to make that occur. And so Any other expenditures that are related to this matter are expenditures that would have to be borne by Ms. Langford because because those are decisions that she would make in determining whether or not she wants to continue some modality of treatment with respect to her dogs. She indicates that she suffered, that is, Ms. Langford indicates that she suffered fear and some degree of mental health depreciation because of the fact that she discovered that her dogs had been fed and that there was a notification of the police saying that she was having a mental health breakdown, and also that information was given to the Animal Society regarding her dogs. And the question then becomes, is her response to what was done, that is, someone came into her home, a family member, and fed her dogs, and called the Humane Society and contacted the police regarding a wellness check, whether those things are of such a nature that Ms. Langford's response to those matters is reasonable. If someone took her dogs from her home and had them taken to the dog pound, let's say they put the dogs to sleep, if Ms. Langford has a mental health breakdown as a result of that, that's reasonable. It's reasonable to expect that if somebody takes her property and puts her dogs to sleep without her permission, that's going to cause a mental health breakdown to persons that don't necessarily have a mental health disease or mental health illness or whatever. If someone comes into her home and locks the doors where she can't come in, that's going to cause a mental health breakdown. But in the circumstance where there is a mental health crisis as a result of the fact that someone fed the dogs because they reasonably believe that the dogs may have been in distress, and they made phone calls for wellness checks, that will cause a mental health breakdown. It's not reasonable that it will do that. That's not reasonable. It's not reasonable to conclude that if persons try to attack or corral Miss Langford because they had a reasonable belief that there was something going on with her, that attempt to corral her and imprison her and take her out of her home and force her to the hospital, and they turn out to be wrong, that could be cause for her to reasonably go through a mental health breakdown that could result in damages, monetary damages, because she has suffered severe emotional distress that occurred as a result of persons that may have had a reasonable belief, but their actions based upon that reasonable belief were far beyond reasonable, far beyond reasonable. And in this case, that did not happen. None of those things happened. And so the ideal and the notion and the testimony that there was a breakdown, that there was fear, that there was some mental health challenges secondary to Ms. McGee coming in and feeding the dogs, is insufficient to establish that there was severe infliction of emotional distress. In this case, it would have to be negligent infliction of emotional distress. And so there would have to be an extreme showing of an extreme incident that resulted in extreme harm to Ms. Langford, because it would have to be negligent infliction of emotional distress. Emotional distress that was unintended. It would have to be an egregious act that resulted in extreme emotional response. Moreover, there is no testimony there is no testimony in this record from which the court could draw a conclusion that such occurred. Such testimony would have to occur by virtue of a trained professional. A trained professional with a license to provide factual information regarding the treatment of Ms. Langford, regarding her mental health before, during, and after this incident, would have to establish on this record that she had suffered a severe depreciation in her mental health condition as a result of an extreme condition that occurred. And none of that is on this record. It's simply not there. And even if there was a mental health professional, I don't believe that there is a mental health professional under the sun that would testify that where an individual came in to Miss Langford's home, a family member, to feed her dogs based upon a conclusion, albeit a wrong conclusion, that she was having a mental health episode, that such would trigger a mental health episode of such a nature so extreme that it would result in extreme mental distress, such that it would be awardable, such that damages would be awardable for such harm. That just didn't occur in this case, and there's no evidence to support that. And I doubt whether there could be any evidence to support that, whether any professional would come in and say that to the extent that Ms. McGee's actions were unreasonable, that such unreasonable action was of such an extreme nature that it resulted in emotional distress of such an extreme nature that it would be awardable, or that damages would be awardable. So that does not exist in this case. Moreover, the other area of testimony regards whether or not there was defamation of character, or the statements or publishing of statements that would tend to defame Miss Langford's character. There was nothing here that does that. There is a indication of seeking of a wellness check, and that wellness check turns out to be something that Miss Langford was well enough then, and she appears to be well enough now. But there was a mistaken belief that it was not. This was not an unreasonable conclusion to be drawn, such that outside resources would be called upon to find out whether or not that was true. It seems here that it turned out that it wasn't true. Thank God it wasn't true. But the question is whether or not there was a reasonable basis for calling. And the court would have to conclude that, for the reasons I previously indicated, that there was a reasonable basis for calling. Although the reasonable basis for calling turned out to be wrong, that's the whole rub with this. Millions of times calls are made regarding wellness checks that turns out to be wrong. And thank God it turns out to be wrong. Sometimes it turns out to be right, where a person has harmed themselves or harmed someone else. But most of the wellness checks, I would, although the evidence is not here on that, most wellness checks turns out to be wrong. It wasn't happening. They thought the person committed suicide, they're still alive. They thought that they were that they were getting ready to jump, they weren't. It just happened to be wrong. In this case, the wellness check happened to be wrong and ultimately unnecessary. The claim with regard to the veterinary society turned out to be wrong and unnecessary. But it was not unreasonable to reach out to resources to see whether or not those resources may have been necessary. Just turned out that they were wrong in this case. I cannot find the malice there. The plaintiff testifies that the malice is associated with the fact that when she spoke with Ms. McGee never told her that she had contacted the Humane Society. I don't find malice in that. I don't see where the Humane Society and not telling her about the Humane Society would be a sufficient basis to establish that there was malice. If contacting the Humane Society was to get the dogs taken and put down, then certainly Miss McGee would not have gone to the property and fed the dogs. It seems to me that feeding the dogs and providing care for the dogs was an effort to make sure that these dogs were demonstrated as being dogs that were cared for if the Humane Society came out. That was be something that was to Miss Langford's benefit. This is obviously, it is a family matter, but again, I have to take a look at it as if it's whether or not it's a family matter, as if it's just a matter where people came into a situation where some things turned out to be right, other things turned out to be wrong. Obviously, there are ongoing disputes in this family. I will never be able to solve those problems, and maybe the individuals will be, but that's not something that's beyond my pay grade. That's not the assignment that I have here today. I certainly wish that families could get along, wish mine got along better. But at the end of the day, I have to apply how the law operates in this particular scenario. And as it relates to the law, I don't see a cause of action on the claims that I've covered. As it relates to getting the dogs checked out, after the dogs were fed and going to a vet and things along those lines, if there was a bill that was generated from going to the vet to check the dogs out, it would certainly be reasonable that Ms. McGee would have taken on that bite for having the dogs checked out. There was a bill generated for that. That would not be unreasonable within the first day or week of the time that those dogs were throwing up or whatever. That would be something that would certainly be reasonable for Ms. Langford to go and say, well, she fed my dogs and I need to check out what's going on with them. And Ms. Langford did that. That was a reasonable thing to do. Even if Ms. McGee had been right, whether she was right or wrong, it didn't matter. If Ms. Langford wanted to have her dogs checked out immediately as a result of the dogs being fed at a moment in time, she had every right to do that and to pass on the cost of that to Ms. McGee. In this case, she was able to, there was some cost that she incurred. The only cost that she indicated to me that she incurred, I believe, was in the nature of $83 that she incurred having the dogs checked out, or some services that she provided to the dog. That's not unreasonable. Moreover, she indicates that, that is Ms. Langford indicates that, that the floor in the property was damaged. Now, it's the burden of proof on Ms. Langford to indicate what the condition of the floor was before and what the condition of the floor was after. She indicates that there was damage to the area where water was placed on the floor, and that area has to be corrected, and that area of correction would cost a total of $150. Now, here's what it's telling in this aspect of the case. Ms. Langford testified that she was having the entire floor, that there was something with the entire floor that was needing some work. She testified that there was other work being done in the house. That was also testified to Ms. McGee, that there were conditions of disrepair. There was nothing in Ms. Langford's testimony that tried to add to any obligation on Ms. McGee's part. The entire room, let alone any other conditions throughout the house. Ms. Langford says that there were a few towels among this floor, and she said on a previous occasion, I think, that she was having the whole floor replaced. But she says in this area there were a few towels, and that to get that area taken care of was going to cost me $150. And I believe that the water to that area is what caused that. Listen, if she was making that up, she would say she would have expanded it. She would have made it more than that. That testimony rings true to me. It rings true to me that something happened regarding the tile on the floor. And the main reason that it makes sense to me, it rings true to me, because there's a bigger area. And Ms. Langford is not including that bigger area. She says that it was a small area, and that's the area that needs to be taken care of. That's what the evidence shows in this case. And I believe that based upon that testimony, as I look at it, that Ms. Langford was able to tilt the scale in that regard. She was able to tilt the scale. Was it done intentionally? Who cares? Was it done negligently? Who cares? Something happened as a result of the water being on the floor, and that water came to be on the floor as a result of actions by Ms. McGee. And so she tilted the scale on that. And because she tilted the scale, she's entitled to the damages there of $150 plus the $83 for the care item that related to the animal. And when I add those items up in this case, it comes out to $253. And I noticed that there were no filing fees that were generated in this case. It looks like there was a fee waiver that was granted in this case. And let me ask you, Ms. Langford, I don't see any filing fees or service fees in this matter. Were there any fees associated with bringing this action?
There was about $36.15 for the service fees for the certified mailing. There were no court service fees. Those were waived.
So she is entitled to recover the $36.15 in this action. And so if I add that, that brings the damages in this matter to $289.15. My judgment is for the plaintiff on the claims as set forth in total damages of $289.15, and for the defendant on the claims of defamation, on the claims of harm to the animals, and on any other claims. I find no cause of action with regard to those claims. And so the award is as the court has indicated in this matter. All right, that is my judgment in this case. You'll receive a copy of my order in the next day or two. All right. I wish both of you well. Good day to you.
Excuse me, is there any way I can get something in writing to the dates off? My paperwork, February.
For today.
Yeah, for work. Mm-hmm.
Okay. Madam Clerk, can we get something emailed to her?
Yes, I just need her email.
Okay, so Ms. McGee, chat your email address, and my clerk is going to send you a work letter to show that you were in court.
Okay, thank you.
Good day to you.